Appellate should surrender by 30th September.
Item number 2, JCRLA 7 of 2011.
The appeal is dismissed.
Judgment item number 3, JCRLA 13 of 2011.
The appeal is dismissed.
For judgment item number 4, WA 64 of 2013.
The appeal is dismissed.
For judgment item 5, WA 500 of 2013.
The appeal is dismissed.
For judgment item number 6, WA 551 of 2013.
The appeal is dismissed.
For judgment item number 7, CRLA 444 of 2016.
The appeal is dismissed.
None appears dismissed on opposition.
Supplementary list item number 9.
None appears.
May I prefer tomorrow because I have to file a translated copy of Odia annexure.
No, you have not taken steps for limitation, sir. And defects have also not been removed for almost 9 years now. 10 years.
A lot of the
Item, my lord,
tomorrow I
item
will,
8, your lordship, no instruction, my lord.
Sorry?
because
Item 8, your lordship, no instruction, your lordship.
8, no instructions. So in item 9, it is already delayed. This is filed 10 years ago.
yes, in the meantime, I received a communication from my party that she was allowed to continue and regularized in 2012.
All that is fine. Unless you take steps for condoning delay, we can't allow this.
It's a
And defects have also not been cured for 10 years now.
Transfer brief and after.
That's all right, sir. Now take it easy.
Lots of me call
Take it easy. Then. Take it easy. You say for last 10 years,
Next,
steps for limitation have not been taken. The
lots
have
of-
also not been removed. The court does not propose to grant any further indulgence in a 10-year-old matter. The appeal is dismissed. Yes.
Lots of call it to next week in the meantime.
All right.
Item number 10.
The council died and thereafter
It's all
the
right.
brief was transferred.
All right. So, all right.
Item number 10.
None appears dismissed on opposition.
Supplementary list item number 11.
11, my lord, state is the appellant. That is against the last 12 years, no stay order has been granted. So
We'll leave the
it's
question
a-
of law open then. There's also a delay. How much?
this
delay?
is regarding handing over a copy of the sale deed to the executant.
Yeah,
And
against the impugned order of the learned single judge. All right. Delay of 69 days is condoned. You say in the present appeal, which was filed 10 years ago, no substantive proceedings have taken place. The impugned order of the learned single judge has also not been stayed. Stop. Consequently, while leaving the question of law arising there from the order of the learned single judge open for decision some other appropriate case.
Supplementary list item number 13.
None appears dismissed on opposition.
Supplementary item 14.
And I am for the respondent, my lord.
All right. None appears for the appellant. Dismissed on opposition.
Supplementary item 15.
None appears dismissed on opposition.
Supplementary list item 16.
None appears dismissed on opposition.
Supplementary list item number 17.
Item 17, my lord. I was filed this readable, my lord. But now I cannot appear, my lord, here because I have already assigned to Central Government Council, my lord. So against the fee order, I pray, my lord, 1 week time, my lord.
No time.
I'll take instruction only. I'll implement.
Sorry.
Return the file, my lord.
Sorry, sir. Sorry. We're not adjourning. These are old matters.
Oh,
Sorry.
yes, I know, my lord.
Sorry. You say
Only to
counsel for the appellant states that he's not in a position to argue the petition appeal. The appeal is accordingly dismissed.
May I please, my lord? I am appealing for the EPF.
Right.
Supplementary list item number 18.
Item number 18, the state is the appellant, my lord. The appeal is of the 2014. There is a delay of 155 days and no stay is there.
I know.
May I pray your lordship, by keeping the question of law open this.
Yeah, the delay is unexplained. There's also been no stay of the impugned order for the last 8 years. Leaving the question of law open for decision some other case, the appeal is dismissed.
Supplementary list item 19.
None appears dismissed on opposition.
Item number 20.
None appears dismissed on opposition.
Item 21.
Lord, I'm sorry, 22.
None appears dismissed on opposition.
22, sir.
22, my lord, these are 3 writ appeals which have been filed regarding the issue. The content is whether for the purpose of loading, unloading outside the area of the mining premises, whether the central government would be the appropriate government or the state government would be the appropriate government. And the Honorable Supreme Court in that national waterfront case has categorically stated that unless it is within the premises of the mines, it will be the state government. But Lord, relying on an order which was passed prior to the notification which has been issued, and in regard to a chromite mines, the writ petition was dismissed by the Honorable Single Bench. But my lord, the factual my lord, development in the meantime is the two of the mines, I think they have, after this 2020 notification, they have been denotified. And the third one, and there has been a merger in the companies. So whether they want to pursue or not, I'll take instruction to that extent, because otherwise it will be a futile exercise. If
Where the mines have closed, anyway, it's a futile exercise, sir.
No, my lord. The third one is not regarding the mines, because the company they have otherwise.
No. So two appeals can go. The third one will adjourn.
All right. That.
Which two have to go now?
My lord, second and third, Rungta mines, the Rungta mines and this Mangilal Rungta, the third one, which has been merged with the other company. So second and third, your lordships may send the first one. The lordships may keep it open so that I can take the necessary instruction, my lord, on the issue.
All right.
And the legal
312 and 313 of 2014, Mr. Nandal and senior counsel for the that on in view of appellants states that in view of the closure of the mines themselves, mines in question themselves, the appeals do not survive and are accordingly disposed of. In writ appeal 311 of 2014, at the request of Mr. Nanda and senior counsel for the appellate, list on next Thursday, 22nd.
22nd.
All right.
Obliged.
No instructions. 20.
Supplementary list item 23.
None appears not.
Supplementary list item 24.
Item 24, I am correspondent.
All right. None appears for the appellant dismissal non-prosecution. All right.
Supplementary list item 25.
None appears dismissal non-prosecution.
Supplementary list item 26.
None appears dismissal non-prosecution.
Supplementary list item number 28.
28, my lord.
Delay.
It is the appellant. This is regarding 24 hours medicine store inside the campus of the that policy is no more survives.
In view of the subsequent developments, the issue no longer survives. The appeal is accordingly disposed of.
Delay 139.
Delay is also unexplained. Both on ground of delay. Right.
There is a delay also.
139 days. So both on both grounds.
Supplementary list item number 30.
Please, my lord. My lord, the order passed by the Honorable Single Judge is under challenge. My lord, here that in an erroneous consideration, whereas the revisional authority already allowed my revision. In appeal also, the same has been conferred in the revision. So far, the settlement act is concerned, two types of revision is there. One is that is a 15B, where challenge the final record of rights. Another is that is 32. 32 is directly an order passed by the settlement authority is under challenge before the member, that Commissioner of Survey Settlement and Land Records. What happened in this case, my lord? The appellate authority passed an order jointly and not inclined to allow the appeal. The same order is carried to the revision by one of the affected party, and the revision also he has lost. What then another party who has also lost in the appeal prefer another revision under section 15B challenging the record of rights with a prayer to correction that the commissioner did allow the revision, only remanded the matter to the Tahsildar, which is also bad in law because that is barred by res judicata. And I brought all these things to the notice of the Honorable Single Judge. I don't know how it has been again say you to prefer an appeal, because there are two types of appeal. One, original jurisdiction is the Tahsildar exercise, then appeal prefers to the sub-collector. This is a remand matter. This is a remand matter to the Tahsildar, because instead of allowing the revision by the commissioner, because commissioner already dismissed the revision, then how he will allow the revision filed by the another person? May I draw my lordship's attention very shortly? Page, my lord, that page 16. Page 16. In view of the above, in view of the above, I am of the opinion that the appellants of both the appeals cases have absolutely not acquired any right, title, and interest over the suit land on the strength of the sale deed and executed their favor by Vaishnav side during year 1977-1984. Accordingly, I hold that the Lowland ASO has correctly passed orders for recording the suit line in
Whose order is this?
Sir,
Who has passed this order?
that order has been passed by the appellate.
Who is the appellate authority, sir?
Sir, appellate authority, that is, my lord, the settlement officer. That order has been confirmed by the revisional authority also. Once the appellate authority has passed an order confirmed by the...
No, which is the order, the Tahsildar against which you went to the High Court?
No. My lord, that is the order. That was the order. And in annexer, my lord, the annexer 2, the same order has been confirmed by the commissioner. Then another party, there are two parties. In one, there have been two appeals, and both the appeals have been dismissed in a common order. Annexer 1. One of the party preferred the revision under section, my lord, 32, and revision was dismissed. And another party, when the final record of rights has been published after a year, then he has also preferred revision under section 15B. And the 15B, the revision, the commissioner remanded the matter to the Tahsildar. He has not allowed the revision, but remanded the matter to the Tahsildar. Tahsildar allowed that revision case. And against that, I prefer the petition here. And Honorable Division also granted stay order from 2000 to 2013. And in 2013, hurriedly the single judge also directed, no, the appeal is there. You can prefer an appeal once the order passed by the Tahsil, you prefer an appeal to the sub-collector. Why should you go for an appeal? This is not the order passed by the Tahsildar originally. Because the remand order passed by the commissioner directed that Tahsildar to verify the record and pass the order. The order is still in my favor.
Anyway. Yes.
Copy is not with me. In any case, your lordship will find this is in exercise of power under Article 227. This is a certiorari matter. And appeal is not maintainable. Single judge has exercised power under Article 227. And there are all the orders were challenged before all the three settlement authorities. And apart from that, what I have, my lauded friend has submitted, after the remand, the Tahsildar exercised power and passed an order.
So that is the question. How can it
No stay, nothing, sir, here.
No stay is required, my lord. Only thing is because there was a stay order of 2000 to 2013. Division bench passed the stay order. The stay order was passed.
Now it has worked itself out, sir. The impugned order was passed in 2014. For the last 8 years, no stay. Pursuant to the impugned order, the Tahsildar has again heard the matter. He's again passed an order. So nothing survives.
No. How the Tahsildar got the power?
Yes.
Once the commissioner also dismissed the revision,
Right.
whether the Tahsildar is also the superior also to pass the order.
Impugned order to learn single judge has been passed in a writ petition challenging an order of the Tahsildar passed in a revision petition under
Annexer 3, Annexer 2. RP case number 279 of 92.
Under the section 15 bracket A of the Orissa Survey and Settlement Act 1958. Full stop. Clearly, this was an exercise of jurisdiction by the learned civil judge under Article 227 of the Constitution. As such, no writ appeal is maintainable against such an order. The writ appeal is accordingly dismissed.
Supplementary list item 31. Item number 31.
None appears dismissed in opposition.
Supplementary item 32.
None appears dismissed in opposition.
Supplementary list item 33.
None appears dismissed in opposition.
Item number 34.
None appears dismissed in opposition.
Item
My lord,
35.
34, 35 and 36 infructuous, my lord.
Order. All three infructuous disposed of as such.
Supplementary item 37.
Obliged, my lord.
None appears dismissed in opposition.
Item number 38.
Item number 38 infructuous, my lord.
38, 39 infructuous disposed of.
Item number 40.
What's the delay? Just find out.
In this case, my lord, that is a delay of 112 days, my lord.
What's the explanation, madam?
My lord, the matter is that due to petition opposite parties, respondent number 1's negligence, my lord, the corporation has lost 12,46,000. Some
These
more.
are not valid grounds, madam. The explanation offered for the delay of 112 days is not at all convincing or satisfactory. Consequently, the court is not inclined to condone the delay.
Delay, my lord, due to that the
File not traced. That's what you say in para 3. When missing, you don't tell us. So we're not able to help you.
pardon, my lord.
Anyway, the delay application is dismissed. Consequently, the appeal is dismissed. Yeah.
Item 41.
Item 41, 42 infructuous, my lord.
41, 42 is a appeal is become infructuous, disposed of as such.
Supplementary item 43.
None appears dismissed in opposition.
Supplementary list item number 46.
None appears dismissed in opposition.
Supplementary item number 47.
57.
None appears dismissed in opposition.
That I appear for the respondent 3, my lord, in this matter.
Order.
His Holiness the Shankaracharya, deeply obliged.
Item number 48.
None appears dismissed in opposition.
Supplementary list item number 49.
49, I am appearing for the opposite part, not 10.
None appears for the petitioner.
I'm for the opposite part number 9, my lord.
All right. None appears for the petitioner dismissed in opposition.
Supplementary list item number 50.
Here, my lord, petitioner is challenging the order dated 3/1/2015 passed by the OP number 3, my lord, for rejecting the grievance of the 50 petitioners regarding to declare the petitioner has displaced person on the ground that there is no such pollutions, my lord. Now, the my lord, the recent development is the my lord. I am filing in the affidavit, my lord, that here, my lord, the entire my lord agricultural lands of the petitioners have been acquired, except my lord, the homestead land. The factory that company is adjacent to the my lord boundary wall of the my lord village, my lord, and there is health hazard. And now recently, my lord, the RDC has intimated to the my lord government that there is a health hazard, there is my lord serious health hazard as well as pollution, and there is no every possibility to stay of the petition on that village. To that effect, my lord, I am filing an affidavit recent, my lord, on my lord. Page 5, my lord, letter dated my 22/12/2021, second paragraph. It has, my lord, as per report of Collector Raigada, in village Dimundi, it is located adjacent to the boundary wall of Utkala Almina at a distance of 300 meters from the rod mill. Due to existence of the near the village, they are suffering from air, noise, environment, and water pollution. An agreement has also signed on 11/6/2012 between Utkala Almina and the villagers Dimundi in presence of the collector. On 3/5/2000, the villagers of the said village trespassed the Utkala Almina premises and forcibly stopped the plant and machinery. You lordship on to my lord, page 6, my lord. Bottom, my lord, last for two paragraphs, my lord. After, my lord, now they have stated that, but after the establishment of the plant near the village Dimundi and expansion of it, the noise and dust pollution cannot be denied. Human rights of safety aspects considers the villagers should resettle at some other place away from the present habitation. Collector Rayagada has also sent recommendation to the government, R&DM letter number 10/12/2008 to declare them DP with direction to the company to relocate land for resettlement, my lord. Now, my lord, they have not done. This is the present situation, and the government has, RDC has also sent to the government, my lord. Now we are suffering, my lord.
Mr. Monty, you have to take instruction.
My lord, this additional affidavit we have received right now.
You take instructions. You say an additional affidavit has been filed with the petitioner enclosing inter alia copy of a letter dated 22nd December 2021, written by the Principal Secretary to the Government, R&DM Department, Orissa. Sorry, written by the Revenue Divisional Commissioner, Southern Division, Berhampur, to the Principal Secretary to the Government Department, Orissa, Bhubaneswar, recommending that the petitioners be declared as displaced persons for the purpose of the Orissa's Resettlement and Rehabilitation Policy 2006. Paragraph. Counsel for the State, learned additional government advocate for the state, Mr. Morthy, seeks time for instruction. 28th November, 28th November.
Supplementary list item 51.
None appears. This is an opposition.
Item number 52.
Item 52, may I please, Your Lordship? This is a case, my lord. The only pair is for a direction to the opposite party number 1 and 2 for disposal of my application for purchase of the Lord Jagannath land pursuant to uniform policy as at Annexure 1, which is pending since 2007.
My lord, I am appearing for Lord Jagannath, my lord. Here the property situate at Cuttack, supposed to apply the land, these are all related to Cuttack district, my lord. Under the uniform policy, it says, my lord, he has annexed the uniform policy as Annexure 3. It says if the property except Cuttack district, Puri district, other property related to other district, concerned chairman of the collector of the particular district being the chairman of the district level land subcommittee, my lord. This is the application he has not filed in the proper forum, my lord. It is the page 27, it is in Odia. Page 27 uniform policy, it is in Odia, it is states, my lord, Justice Das can Puri Jilla व्यतीत अन्य जिला मानक थिबा जमी पई इच्छुक क्रेता माने जिला स्तरीय लैंड सब कमिटी चेयरमैन को निकट रे दरखास्त प्रिस्क्राइब्ड फॉर्म रे दाखल करिवे. So he has to apply before the concerned collector, who is the chairman of the district level land subcommittee, and he is the authority. He has to do all the necessary works, determine the market price, everything. And after, Millard, this is the property status is Amrutamani, Millard.
Yes.
Your Lordship knows, Millard, as per the judgment of Honorable Supreme Court, the property always belongs to Lord Jagannath, Millard. This is the property, so it is property, Millard. So, and he has not annexed the under the uniform policy. He has to satisfy to the concerned district level land committee chairman that yes, he was in possession of the property since long and he has acquired the property in a proper way. He has not annexed all those documents, my lord.
Who says? This application was filed before the collector cut off. This application, Annexure 1, was filed before the collector cut off, who is the subland committee's chairman. It is not filed directly Puri. It is filed before the collector cut off, which is pending. And he says, I have not given any documents or anything which shows that I have there.
But Annexure 1 reveals that it is in the Puri administrative office.
Yes,
it is
that is the form.
not
that is
the collector. Where you are saying that it is.
If that is why they were objecting it, let your lordship give me a liberty. I will file a fresh application before the collector.
That you do.
That can be.
Counsel with the petitioner seek leave to withdraw this petition, liberty to file a fresh application before the collector in accordance with law.
Yes.
Under the uniform policy.
Liberty is straightforward. Yes.
Under the uniform policy.
Whatever, sir, you file it in accordance with law website. Yes.
Problem.
I will be forbidden, my lord. My lord, I will be forbidden. Item 49, I want to withdraw the case if
49 dismisses withdrawn.
Okay.
Item 53.
53.
None appears this was not.
My lord, I am appearing for opinion number 5.
All right.
Item number 54. Item number 55.
Infructuous, my lord.
Infractuous, all right.
Infructuous.
Disposed of as infractuous, all right.
Item number 56.
None appears disposed now.
Item number 57.
56, well,
Yes, yes.
56.
56.
56.
56, maybe passed over. His file is
Pass over,
maybe passed over.
all right.
Item number 57.
None appears disposed, no opposition.
Item number 58.
May I please, Lordship, my lord. The petitioners in this present petition in the matter, the PIL challenged the action of the opposite parties in filling of the Jalasaya without following the due procedure, my lord. Lordship, kindly glance to annexure 1, that is the ROR. The ROR stands in fourth settlement as Bondo, that is village fund, my lord, which corresponded to fifth settlement ROR, that is annexure 2, my lord. There is also Jalasaya, my lord, village fund. And while the matter stood was, my lord, the OP number 6 starting by filling the Jalasaya, and the present petitioners highlighted the grievance before the collector annexure 4 series, page 23, my lord. But when no action has been taken, the present petition approached this honorable court. This honorable court issued notice, and the OP number 2 and 4 has filed counter affidavit. Lordship, kindly glance to the counter affidavit filed by the OP number 2 and 4. Page 28, internal page 2, my lord. Para 7 of the counter affidavit.
Yes.
That in reply to the assertion made at paragraph 5 of the writ petition, this deponent humbly begs to submit that the petition number 1 had made one representation to the collector Suvarnapur on dated 28/5/2020, ventilating his grievance and praying for restoration of Jalasaya with a copy to sub-collector Sonpur, OP number 3, BDO Tarbha and Tahsildar Tarbha, praying for immediate action and restoration of Jalasaya. On receipt of the grievance of the petitioner, the sub-collector directed the Tahsildar to inquire into the same. Well, it is important on field verification. The Tahsildar found that R filling has been made over plot number 1198, but the same is old work, but it is not known by whom the said work has been done. The GP authority is not involved for such work or giving no direction for such work. Further, there is no government sanction or order to decar from plot number 1196. Then Lordship, kindly para 9 of the counter affidavit. That in reply to assertions made at para 7 of the writ petition, this deponent humbly begs to submit that petition has alleged in this paragraph that OP number 6 has installed some pillars for construction of community center over Jalasaya. Client and the other opposite parties are sitting silent in the matter. The allegation is baseless as Panchayat Executive Officer JE and Sarpanch of Baghia GP has submitted report by its letter number such and such, dated such and such, that one project, namely construction of Kalyan Mandap at village Baghia for the public executed by Baghia GP by case record number such and such with an estimated cost of rupees such and such under 14th Central Finance Commission grant, and the first and final running account bill has been prepared for rupees such and such. The Tahsildar, it is important, the Tahsildar Tarbha has submitted the report in the matter by letter number 1947 dated 6/7/2020 that the R filling work has been made over some portion of plot number 1198. That is the plot over with the Jalasaya existing out of an area of acre 0.3 decimal. Further, he has also reported that 6 numbers of concrete pillars have been constructed over plot number 1195, Kisam Onabadi, Bondhadi, area acre 0.001 decimal is holding number 137. The report of Tahsildar Tarbha states that no irrigation facility, compulsory basic water rate have been granted to any farmers from this source. Then Lordship kindly have a grants to the report, my lord. That is page 34, internal page 8 of page 30, running page 34, my lord.
Yes.
On field verification and on the basis of report of Revenue Inspector Brahmani, it is ascertained that Earth filling work has been made over plot number 1198. That is over Jalasaya plot, my lord. Kisam Jalasaya within bracket Nuaband area acre 0.300 decimal. Further, it is also found that 6 number concrete pillars have been constructed over plot number 1195. Kisam Adi, Bandha Adi area such and such, my lord. The case land is in holding number 137, plot number 1195. Kisam such and such, my lord.
Such and such type of.
Kisam Adi area.
Yes.
That is Bandha side, my lord.
Not Jalasaya. That is the main. You are saying such and such. That is the crux. It
My
is
lord,
not Jalasaya.
Adi means, my lord, when there is a village pond, the four corners of the four sides of the Bandha is stated to be the Adi of the Bandha, my lord.
That Adi is not the only 1 decimal of land is covered by that Kalyan Mandap, which is recorded as Adi, and it is not affecting the bathing purpose of the pond or any.
But my lord,
irrigation.
the government spreading para 9 that some portion of plot number 1198 over with the Jalasaya existing has been filled up, my lord.
Their allegation is that it is Jalasaya, but it is not Jalasaya. That is, it is Adi.
My lord, the ROR shows that annexure 1 and annexure 2 that it is Jalasaya, my lord. Lordship kindly glance to
page 8 of my counter affidavit.
Lordship kindly glance to page 14, my lord. The current settlement ROR plot number 1198 Kisam Jalasaya Kisam Bistarita Biborani Chohodi Nuabandha, my lord. And when the opposite parties are admitting that they doing construction work over some portion of the 1198, that is mean for Jalasaya, the order for restoration of Jalasaya is to be passed, my lord. And there, by constructing community center, the opposite parties are trying to change the nature and character of the Jalasaya. In inquiry report of the Tahsildar has also said that para 1, my lord, that 6 number concrete pillars have been constructed for 1195. And initially on field verification on SSB report Inspector Ramani, it is ascertained that earth filling work have been made over plot number 1198.
No, but status quo was asked to be maintained by this court. What has happened?
My lord, it is still continuing. It is still continuing.
Continuing.
Do you still need to construct that Kalyan Mandap?
Yes, my lord. That is the counter affidavit that it is already constructed to certain extent.
No.
And if there is a status quo, it must have been stopped after the status quo order is communicated. That is on 30th.
How far has it been constructed?
That I have to current status of the Kalyan Mandap.
Current status of building in question be ascertained by the council of the parties. Status quo to continue. Status quo order to continue till the next date. 7th December.
Supplementary list item 59.
None appears to sustain opposition.
Item number 60.
May I please, let's see. This matter is related to PIL matter. Opposite party number 6 to 9 constructed a house, Latin and blockage the road of general public not pass away. Opposite party number 5 laws FIR against them, and also petition number 1 laws FIR against the opposite party number 6 to 9. Till today, my lord, they have blockage, no pass, 2-wheeler, 4-wheeler not pass this road. Annexure 3 may kindly see. Entire photocopy, my lord. They have encroached the government land, madam.
60.
These illegal encroachments which you say, who are those encroachments?
Opposite party number public 6 to 9, my lord. Kanna Behera, son of Krishna Chandra Behera.
But you seem to have already lodged FIRs.
My lord?
There are already 2 FIRs.
My lord.
So what is happening in those?
Also government.
What is happening in those FIRs?
OP number 4, junior engineer, works department.
No, the result of the FIR. From the FIR.
My lord, 2020, no action, till today, no action taken the police officers.
Do you want to find out what is happening?
Please, I'll take instructions.
At the request of Mr. Ishwar Mohanty, learned ASC, who wants time for instructions list on. 21st November.
Supplementary list item number 61.
61 is phrase, my lord, criminal appeal. LCRB called for, let's see.
Yeah, LCRB called, admit LCRB called for.
To my lord. And a live conviction, right? No other witnesses have seen.
This is not pressed at this stage. You see, paper books be prepared within 8 weeks and supplied to counsel of the parties. Thereafter, the matter be included in the list of final hearing matters.
My lords, may I pray the bail application will have collection of LCR because my lord.
Not now, sir. Not now. Yes.
My lords, your lordship, kindly have a glance because the case is based upon entire witnesses not to prove the case. Only on version of the doctor, my lord, that this cannot be, my lord, injury cannot be sustained on body by a stop that conviction has been made, my lord. Only a circumstantial basis. May I pray only bail application will be hard after the LCR is received, my lord.
No. You file a fresh one. Yes.
Yes, ma'am.
Item 62.
Lordship, item 62, appellant convicted for life.
No, not admitted yet, is it?
Not well, it's for fresh admission.
All right. Bail is not pressed at the stage, fine is stayed. To be included in the list of final hearing matters after the paper books are supplied to counsel of the parties.
Item 63.
63 also same, convicted for life, your lordship.
Same.
Item number 64.
Same.
64 also same.
Supplementary list fresh admission item number 65.
Obliged, your lordship.
Almighty.
Your lordship, item 65. Your lordship, in this case, the petitioners of the Brahmanan village have approached this court for seeking a road because seeking a road or overbridge for their commutation. Your lordship, if your lordship may kindly peruse the village map, your lordship, then I can present the case in a better way. Lordship. Page 18. Page 18 of the petition, your lordship. This is a sketch map, your lordship, which has been prepared. This is the sketch map of the village which has been prepared, your lordship. The village has been distributed on two sides of the rail track, your lordship. This is the main line between the Kharagpur and the Balasore, and the village is distributed on both sides of this rail track, your lordship. But there is no under for the commutation of the villages, your lordship. And the gate number 58 and the gate number 59, your lordship. If the villagers have to come to the have to commute within the village itself, your lordship, then they have to cross from gate number 58, then again come back to gate number 59, and then they can after their approach to various facilities. And as it is evident from the map, your lordship, the various offices such as the PWD office, block office, hospital, and all other offices are spread all over this village.
Representation, sir.
Your lordship, several representations.
All right. You see the petitioner's representation bracket annexure 3 series. Be examined by the railways, Southeastern Railway, is it? General Manager, Southeastern Railway, bracket, opposite party number 2. And after giving the petitioner hearing, a reasoned order be passed. This, Mr. Marty, the way it works is the government has to write to the railways, right? That they want an additional.
Initiation has to be made through government.
Your lordship, several government schemes are also there. I have annexed the various schemes under which.
So what is the state government's response?
Should I file a reply?
Yes. You see, notice. Mr. Mohanty accepts notice for opposite parties. 4 to 9 and states that he'll file a reply within 4 weeks. Reply the railways also be filed within the same period. Mr. PK Pari accepts notice for 1, 2, and 3. Rejoined at the act of any before the next date. 5th January.
Supplementary list item 66.
May I please, this case, my lord, the listener came to know from the Delhi newspaper, my lord, Pramaya, and also, my lord, the Indian Express, that the government of Orissa going to set up a cement factory inside this Subhashi jungle forest, my lord, forest, my lord, reserve forest, Subhasi reserve forest, my lord, by cutting older
So you
trees.
can go to
my
the NGT, sir, for these.
lord.
You can go to the NGT for this. Permitting the petitioner to approach the National Green Tribunal, Kolkata bench. In accordance with law, the petition is disposed. Yes.
Supplementary list item 67.
None appears disposed in opposition.
My lordship, I am appearing, my lordship. I am appearing from the petitioner, my lordship.
Yes.
No instruction from the petitioner, my lordship.
No instructions.
Supplementary list for orders item 68.
68, no instruction, your lordship.
No instructions. The IA disposed.
Item number 69.
July, sir. More than a year.
I apologize, your lordship. It's my mistake.
No, what's the matter about?
This is regarding, my lord, I am difficult to place because the prayer, that page is missing. So
No, it's about some pollution control board.
No, your lordship, that is not regarding the matter. The regarding matter is that when there was a direction for establishment of industries manufacturing plastic, thereafter it has been arbitrarily stopped without even hearing and without any breathing period to us. So the notification is under challenge. The lordship may grant me only 1 week time to remove the defects.
No, there's not even a prayer clause here, sir. There's no prayer clause also in the petition.
My lord, that is I take apology because the prayer phase is missing. So your lordship may permit me to only 1 week time to remove the defects.
Last opportunity.
Prayer page is also missing here. Let him be directed to.
I'll remove it.
To remove the defects within a week. Failing which it will automatically stand dismissed without any reference to the court.
Item 71.
My lord, 71, my lord, infructuous, my lord.
Infructuous dismissed.
Item 72.
Item 72, my lord, there have been some new developments in the matter. Kindly grant us 2 weeks time to file an amendment.
Withdraw it, file a fresh petition. In view of the subsequent developments, counsel the petitioner seeks leave to withdraw the present petition with liberty to file a fresh petition in accordance with law. Dismissed as withdrawn, liberty is paid for.
Supplementary list item 73.
The memo is taken on record, no instructions.
Item number 74.
State.
So, please wait. This is an appeal. My lords, this was listed on 22nd of August. My lords, I have filed a fresh IA. My lords will find it is IA 2924 of 2022. If my lords.
The second case is the leading case, my lord.
Yes, my lords. My lords, the short issue is that, my lords, in this petition, the stay was not granted. But in the lead petition and other petitions, my lord, stay has been granted, and plus the issue is that contempt proceedings may be initiated.
The impugned order of the learned single.
My lord, the contempt orders, my lords, will find at page
IA 2924 of 2022. The impugned order of the learned single judge shall remain stayed during the pendency of the appeal. When is the main?
That's 1st of November.
1st November.
List on 1st November along with the connected matters.
Only one thing, Lord, let them not be disengagement. Because all of them have been continuing.
Yes. Anyway. Yes.
Item 75.
May I please, Your Lordship? This is third round litigation, my lord. To that extent, I want to draw your attention at page 20, annex 5. Initially, Your Lordship directed at page 22, my lord. May I please, my lord? The petition's representations fund shown will be considered by the collector and municipal Jagassimpur opinion and on its merit after giving opportunity of a hearing to the petitioners opposite by note 5 and reason order be passed thereon not later than 4th October 2021. The order be communicated to the petitioners not later than 11th to 10/21. If the petitioners are aggrieved by such decision, it will be open to them to seek other appropriate remedies then accordance with us. Then thereafter, my lord, Well, kindly see at page 24. In response to your lordship's direction, my lord, the OP number to the collector passed in order 18/11/2021, my lord. The relevant portion is at page 27, my lord. Got it, my lord?
Yes.
May submit the from the bottom, that is the 11th line, my lord. Hence, I do hereby direct, my lord, got it, my lord, to the executive officer Jagatsinghpur to take immediate necessary steps to repair, renovate such road, which is used as approach road by the villagers, and also access the cost of damage, and the same be recovered from OP number 6 under OPDR Act. Then thereafter, my lord, as because they did not carry out the said order, I took the shelter of this honorable court again, which will clarify from Annex 8 at page 30, my lord. Then thereafter, my lord, at page 32 is the relevant portion, directed the executive officer to be present personally, my lord. At page 32, my lord, may kindly see your lordship's passed on order 11/5/2022. An affidavit has been filed by the executive officer Jagatsinghpur municipality enclosing photographs of the repair road. Apparently, the repair work was carried out yesterday. It is stated that the authorities were awaiting the completion of the municipal election to begin the work. In response to the same, my lord, may kindly see 33, the work was completed, my lord. Then thereafter, the self-same person has also done this, made the same hole in this, which will clarify from Annex 30, page 34. To that extent, we made also bring to the knowledge of the collector, my lord, by Annex 10, my lord. Now the villagers, in spite of the direction and in spite of the works done by the collector and executive officer, now again, same thing has been repeated by the self-same person, the OP number 7, my lord, by without taking into consideration the order of this honorable court and also the decision which has been taken by the executive officer, and the work has already been completed. Again, he has made the whole. As a result of which, villagers are not able to go on that road, my lord, which will clarify from the Annex 9 series. So to that extent, we made a representation to the collector, bringing all the difficulties. Now the situation is like this, my lord.
What's this repeated problem? Same problem again and again.
Yes. Millards, if this representation has in fact reached the collector.
No, you first repair this road, sir.
Yes, Millards.
Again, all this representation, endless representations are not resolving the issue.
Millards, we'll repair that.
You see, endless representations and orders passed with this court have not had the effect of a gaping hole in the concrete road of plot number 3258. P.O. Chatara, Deboga.
Yes, ma'am. At page, at para 5, my lord, page 3. The villagers of village Devabhog.
No, the road, where is the road?
This is the road, my lord. I have categorized.
No, connecting which to which point?
That Harijan Sahi, that Chhatra, my lord.
And?
Harijan Sahi Chhatra in the state of Jagatsinghpur, my lord.
No, the road must be going from one point to the other, sir.
No, that in that village, that particularly that has not been given, my lord, to that extent, my lord. In that village that is running, in the middle portion of the village.
In village Deboga.
Much obliged.
Kantunia Harijan Sahi has still not been repaired. In fact, on the previous occasion when this court passed an order permitting the petitioner's representation, directing the petitioner's representation to be considered by the Tahsildar, he passed an order on 18/11/2021. Sorry, the collector. He passed an order on 18/11/2021 acknowledging the whole had been created, which is a public nuisance. Nevertheless, the problem persists. Paragraph. Mr. Ishwar Mohanty, learned AC, states that he will immediately seek instructions. Yes. It is directed that the collector should examine the matter immediately and ensure that the hole in the road is immediately filled up and report compliance by the next date. List on 1st November.
Supplementary list item 76.
May it please your lordship. My lord, I'll just start my submissions by reading out of one small observation of the Honorable Supreme Court on 28/1/2022 that it's an old saying that the difficulties of the litigant in India begin when he has obtained a decree. Now, this PIL, the petitioner is trying to highlight the complete logjam prevalent in Orera, where not a single order is being able to be executed till date. Your Lordship may kindly turn to page 47, which is my RTI reply, which they have given.
Anyway, we'll issue notice on this.
I have the instruction for Lord to appear for the Orera. I will file my Bakalat Nama.
All right. Mr. BP Tripathi accepts notice on behalf of opposite party number 2, Mr. Ishwar Mohanty on behalf of opposite party number 1. Replies be filed by both within 4 weeks.
So Orera is saying we don't have any manpower, but they have to themselves execute it because the order is a decree of the civil court. So they do not need any manpower. And 3 years, 4 years cases are still pending execution cases.
The petitioner is that orders of the Orera are not being executed despite repeated attempts by those in whose favor the orders have been passed. Full stop. It is submitted that this kind of a stalemate frustrates the very purpose of setting up an authority like Orera. Both counsel for opposite parties 1 and 2 will come up with some concrete solutions to the problem and place them on affidavit by the next date.
They're just sending it to civil courts, which is completely frustrating the purpose of the act. Another 10 years will have. Not a single case has been registered by the civil court till today also. It's just lying in cold storage. Poor people, they are not even able to get their possession. And Rera himself is writing, we do not have power, we do not have magistrate power. When the power of civil court has been given to them, how they are making such observations?
What is happening in other states?
My lord, they have their own officers who are executing in Orera. Because the power is there under the rules that the RERA will execute it, and in case of its inability, that if the assets are lying outside its jurisdiction, outside the state, then it may transfer the decree. But within your jurisdiction, they have to do it.
So they have to register an execution case.
Yes. Now they register the case, they sit over it for 3 years, and then they send it to civil court. So I completely fail to understand then why this 3 years, 2 years, they keep it with themselves. It's a complete logjam there.
There is a provision, my lord, which is there.
Then is it
not being place 28.
Why is it not being implemented, sir? That's the only question.
It has been sent to the civil court. Now his complaint is
no. You are sending it to civil court after 3 years. You're keeping it with you for 3 years.
So we don't, my lord, after the orders are being passed.
So why would he file a petition? He's just casually coming into the court. I mean, he's obviously got a grievance, which is why he's coming to the court.
He has his grievance, my lord, but we are sending it to the court, my lord.
No, but sending it when? He says you're sending it after 3 years. And why should you send it?
We will file a reply, man.
Just I'll read one observation in order of execution case. In case of delivery of possession, civil court is well equipped under the provision of Order 21 to enforce an order to the process of the court. The authority does not possess the power of magistrate to direct a party to serve civil prison. Even it may not be possible on the part of the authority to take the extraneous help of police for enforcing its order. The authority has no manpower to execute its order. All these are incorrect. They have the power of the civil court under the rules. And if it is if no manpower, then they should have asked the state government. But it's a complete logjam, no communication between them. Even the chief secretary had held a meeting to sort it out, but nothing. I've also annexed those documents. They must be proactive. This is completely frustrating the purpose of the act. Let the Orera secretary appear and say, what does he mean by I don't have manpower? You are the court itself has to issue a direction to the police. He will issue attachment or receiver. He can appoint receiver. But for that, you don't need a manpower for that.
In the same manner as if it were a decree or order made by the civil court.
I've annexed it. This rules was also absent. I had filed a writ petition, then this rule was framed. In the event of his inability to execute, he will send. If the assets are outside, then as per section 35 of CPC, he has to send it to outside. But here, all the assets within 5 kilometers,
so they should have their own bailiffs to go and attach.
Yes. They can give it to anyone.
I'll also, my lord, see that in other states, how are they executing it?
Correct.
what is the procedure, my lord? That also
We need to see our state is doing nothing. Neither Orera nor the state government is sorting it out.
That is your complaint. We will file a reply to that.
But a solution has to be found, not simply filing a reply saying we have no power.
Not a single case has been executed till today, since the inception of Orera in 2017. Let that officer on VC, he may explain for 5 minutes what is the problem. It can be sorted out.
On the first date, my lord and friend is saying that.
No, he has
given me a copy yesterday. I'll file a reply.
No, but also take instructions,
my lord,
on how to resolve this issue. Counsel to the petitioner says, draws attention to an order dated 8/11/2021, passed by the Orera Bhubaneswar in execution case 6 of 18. No, order dated 7/7/21.
18/7/22. That observation, your lordship is looking for that?
That's 18/7, is it?
18/7 at page 43.
And order dated 18/7/2022 in execution case 59 of 2021, passed by the Orera, stating that it is helpless to execute orders even for realization of amounts. Since it does not possess the power of a magistrate to direct the party to serve civil prison in case of its violation. We'll stop. Mr. Agarwal points out that this is an erroneous understanding of the powers of the RERA under the RERA Act, as it has adequate powers as any other civil court enforcing a decree has. Tripathi states that he will seek specific instructions on how the process of execution of the order 1st November.
The state may also file an affidavit.
Yeah. State 21st.
Obliged.
Supplementary list item 77.
My lord, there is only notice has been issued and delay, my lord, around 60 days delay, my lord. Notice has been issued.
All right. What's the matter about, sir?
Matter relating promotion, my lord. That's a fixed date, my lord, because the practically, with all respect and regard, my lord, we are receiving list around 9:30, 10 o'clock.
All right. At the request of Mr. Senior Counsel, delay is condoned. You can condone the delay. List on 5th December.
Supplementary list item 78.
78, my lord. On behalf of the senior advocate Ramakanta Mahans, my lord, he is on a little legs, my lord, that it may be taken up tomorrow.
Mr. Ramakanta Mahanti, the senior counsel for the appellant, stated to be in some difficulty today. 6th December.
Supplementary list item 79.
Item 79 is the appeal by the state. And that period of a delay which has been pointed out, so it is within the COVID period. Delay.
All right.
And here the Honorable Single Judge has quashed the select list of the year 2014 by directing to redraw it. Even though in the meantime, there are already 2 other selection processes have been completed, and on the erroneous assumption of fact that they were eligible, in fact, they are not eligible.
That is on merit that the delay be condoned and date may fix for
or delay in filing the appeal is condoned since the delay is on account of the intervening COVID period.
And I am giving a list of other connected matters because this judgment has been passed in batch of cases.
Yeah, notice, he accepts notice. List for final hearing on 10 January. There shall be stay of the impugned order of the on a single judge in the meanwhile. And then all these connected matters taken on board, same order. But who's for the respondents in these matters?
The notices have to go, my lord.
My lord,
I will file make mention tomorrow for listing it in the batch of other cases, and I will show this. It will be better, my lord.
Let these
matters be appeared in the cause list so that they will be.
Correct. Yes, correct. They can appear.
These cases at tag EFG.
All these interventions are allowed. Applications are allowed.
It's
Intervention applications are allowed.
Connected rate application.
In their case also, we have filed a appeal.
Order has been passed in their favor. In the writ appeal, which my lord is.
I am saying we have filed a writ appeals against those in those cases also where my
anyway, these interventions also.
My lord. Great.
Supplementary item number 80.
Mr. Mayor, please. I have obtained a decree against the respondent number 1 as early as in 2009. In 2016, I filed in the execution case. I got the delivery of possession, and thereafter the respondent has filed a petition before the executing court, before the trial court under Order 9, Rule 13, along with an application under Section 5 Indian Limitation Act. Notice and limitation was served on me. I appeared. When the matter was going on, evidence was led in the limitation petition, other things were going on. There was a transfer of presiding judge, and then he started saying that evidence should be taken up on Order 9, Rule 13 also. Unless the delay is condoned, that cannot be done. Then I came before this honorable court. This honorable court has given a clarification that limitation petition should be disposed of first. Since all the petitions are before the trial court will pass orders in accordance with law. Thereafter also, the trial court said, no, I will dispose of both the matters. In the other matter, in the Order 9, Rule 13, I have no notice. Unless it is admitted, there is no question of leading evidence on that. So now
how is a writ appeal maintainable, sir? How is a writ appeal maintainable?
I understand that, but the problem is, Honorable Single Judge has earlier held that this
SLP sir can only go into the Supreme Court against this. You say against the impugned order.
But if one observation is given, it may sort out the problem. That now that the hearing has already taken place before the trial court under Section 5 Limitation Act, let him pass orders on Section 5 Limitation Act that's posted for arguments. And in the event he is condoning the delay, let him give an opportunity for Order 9 Rule.
You can't entertain it. So the whole problem is that. See, against an order passed by the single judge in CMP number 268 of 2022, arising out of civil suit 128 of 2002, writ appeal as such is maintainable. Consequently, leaving it open to the appellant to seek other appropriate remedies as may be available in accordance with law, the appeal is disposed of, does not entered.
Supplementary list item 81.
May I please, your lordship. Here is a case, my lord. The respondent number 1, by misleading, filing a false document before the honorable court, obtain an order, my lords. And my lord, may I draw the lordship's guidance to Annexure 3, my lords. Let's see, may kindly have a glance. A pond was action, even though it is not the assets of the panchayat, my lords.
See, if it's a fraudulent document, you can go for a review petition, sir.
My lords, I have challenged the order of the honorable single judge here.
So you can always go before the single judge with the review petition.
My lord, I have filed a petition for recall of the order by annexing the documents which is in favor of the sole source.
Where is that order?
Where the final order is at, my lord, annexure 9, my lord, running page 35 to 40.
I see. Or notice returnable 3rd January. In the meanwhile, the impugned orders dated 24th August 2002, as well as 6/9/2022, shall remain stayed.
Deeply obliged.
Supplementary list item 82.
May I please, Your Lordship? Lordship, on behalf of Mr. Mishra, 1 week time to remove the defect, Your Lordship.
Fresh matters, please.
All right, you say admit the LCRB for acquisition.
Only copy to sort on me. State copy has not been sorted.
Yes, Your Lordship.
There are no applications, is it? The LCRB requisition, the paper book be prepared and supplied to parties within 8 weeks. To be included in the list of annual hearing matters thereafter.
Item 83.
So, may I please, Your Lordship? Life sentence against the accused persons.
Same. Admit LCRB requisition. Paper books be prepared within 8 weeks and supplied to counsel the party. This fine be stayed. Bail is not pressed at this stage, is disposed. Correct.
List 84.
Well, item 84, no instruction.
No instructions dismissed.
Item number 85.
I will take fresh notice because they did not back or on for.
No, it's a 2014 matter, sir.
Yes, because this is a private finance company, arbitration clause is there, and I am challenging the Learned Single Judge order directing to release the vehicle. Already arbitration proceeding initiated by the finance company, and yes, also notice has been served on the opposite party, but he has filed this writ application. So this one report, it is only settled that federal GST or the private finance notice is maintained. But that was the expert order. In a read, without notice, giving notice to the financer, that order was passed.
There will be no stay of the order, sir. Nothing remains. That order has worked itself out now. 18th August says he can deposit in installments. There's no stay of that. There has been no stay of the impugned order of the Learned Single Judge during the long pendency of 8 years of the present appeal. Meanwhile, the impugned order, which permitted respondent 1 to deposit the balance amount owing to the appellant in 6 equal monthly installments. Ought to have worked itself out. The liberty is already granted to the appellant to repossess the vehicle in there's any default in payment of the equal installment. Given the nature of the relief granted, the court is not inclined to interfere. The writ appeal is dismissed.
Supplementary list item 86.
May I please, Your Lordship? I am on BC. Your
Yes.
Lordship, on behalf of Senior Advocate N.K. Mishra, may this matter be taken up some other day as he's on accommodation and he has gone to Allahabad for Asthi Visarjan, Your Lordship.
Yes, in this batch of cases, I am appearing for Milord's writ appeal number 445 to 453 Milords. Because in this case, Your Lordship was pleased to direct stay of judgment of Honorable Single Judgment Milords, wherein the judgment of the EPF tribunal has which has been allowed in favor is reverse Milords. Because Your Lordship was pleased to grant stay of judgment, notice was issued, but delay has not been condoned, Milords. Okay. And I was told that to remind us so that.
All right. Delay, wherever delay has to be condoned, you condone it.
Plus, flag B, miscase number 682. I'm giving a list of miscases.
You're for whom, Mr. Sahu?
Yes, I am happy. Lordship, kindly see the last number starting from writ appeal number 445 of 2016.
Oh, I see.
BD Supply Co. and all subsequent years.
All right.
Your Lordship, fixing some date.
And then all MCs for dispensing with certified copy, that's allowed. Then for wherever there's a stay, put all of them, you said till during the pendency, these appeals, the impugned order of the learned single judge shall remain stayed. This stay is made absolute and all these MCs are disposed of. You see Mr. N.K. Mishra, learned senior counsel, appearing for some of the appellants, stated in personal difficulty today. In order to continue. Next one. 30th January.
Much obliged.
Obliged.
Let's stay. So this.
Supplementary list item number 88.
88. It will be taken up at 2 p.m.
Yes, 87 at 2 p.m.
87 2 p.m. 87. Okay.
88.
88. Sorry.
Sir, may be allowed to brief. Sir, State Selection Board is the only recruiting agency to conduct the examination for recruitment to the direct post of lectureship through the states to all the non-government aided colleges. After a long gap of about 23 years, it has conducted the written test. I appeared it on 15th April 2016, enlisted within the 265 Viva list on 22nd 2016, and then appeared for its interview on 6th May 2016, whose final result has been published on 8th August 2016 with 99 selected candidates in physics, including 49 in your categories.
You've already crossed 42 years in July 2017 itself, sir.
No, that is I have challenged, sir, 19,306. I have challenged the upper age relaxations. The case is drawn to the original case.
No, but how can you be granted relief in this if you've already crossed 42?
So let me, sir, brief at least. This hear the case.
No, it becomes purely academic, doesn't it? Sir, if we cannot grant you relief.
No, it is actually, sir, the original case is 2757, where I have appeared, I have enlisted, and still, as per the annexer 3 to 7, I have enclosed. There is second counseling to that post has already been conducted. But still, there is cases of non-joining cases are there. I have given representation to Honorable Minister, to Principal Secretary, to make a provision for the merit list. I have also, since there is no provision for merit list in the beginning of the, from the very beginning, I applied for the merit list through RTI Form A, which was initially denied. Then subsequently RTI Form D, the merit list, the rank provided to me was an ambiguous one, and for which I have given representation to Principal Secretary and then to Chief Minister, sir, but nothing worked out. For which I filed the writ petition 2757 of 2017 along with the Miss case 2351. Sir, during again the second counseling conducted, and as I have annexed in the annexer 3 to 7, there are still cases of non-joining. And to mention here, sir, there is 2016 and 17 vacancies. There is no such conduct of examination for which I am otherwise eligible. Now, instead of following the rule 10.1, 10.2, 11.3, 13.2 of SSB, rule 1992, to fill up those vacancies accrued and the non-joining cases from the SSB 2015, the Director of Education has requested government to employ guest lecturers as I have mentioned in which is a very
Flagged it like that.
governmental exploitations of meritorious candidate, as mentioned in clause 14 and 15 of the order of this honorable
Here
court
there is nothing
in 12,250 Annex 23. Sir, you can see also in Annex 21, the government has also requested, the date was 27 July, which is just immediately after the second list. And during the pendency of the case, the original case 2757 and its miss case, there is another advertisement came up in 12th November 2018. And there is no provision for participating candidates like me, though who are eligible to apply, appear for those vacancies of 2016 and 17. Therefore, I filed the writ petition 19,306 of 2011 challenging the Odisha Civil Services upper age limit second amendment rule 2015. This debarred me from participating the 2018 recruitment process. Then I submitted an offline application form that was rejected, sir. And then my interim application I have submitted to this honorable court on 2018, that was also rejected. 2021 participations also have been rejected, making me this court only eligible to one time throughout my lifetime to appear such a recruitment process, whereas most candidates have already appeared it 4 times by now and still may to come also. And to mention here, sir, DP posts are actually fully aided post. And why such amendment 2015 second amendment regarding upper age relaxation only to civil service participants? That is why I have challenged this one. And it is actually paradoxical because it seems that the two rulings for the same examinations for the DP post. And in this connection, sir, you can see the clause 8, clause 11, clause 13, clause 19 of order of this honorable court in 2778 of 2012, annexure 40, sir, may kindly be seen. Sir, therefore, I pray my lordship that to allow my original writ petition 2757 of 2017 and direct the opposite party to appoint me with effect from 2017 and also declare the Orissa Civil Services fixation of upper age limit second amendment rules 2015 as ultra virus, so that a lot of meritorious candidates, sir, who are waiting and suffering because of these irregular selection procedures, they will be able to participate in the future recruitment to come. And this is being a noble profession. This is what actually I want to give, sir.
Are you prepared to listen, sir, now?
Yes, sir.
Are you prepared to listen?
Sure, sir.
Have you seen the counter affidavit filed by them?
Sir.
Do you have anything to say on the counter affidavit filed by them?
The 2 counters I have seen, sir.
You have anything to say on that, sir?
Yes, sir. Anything you can ask. Regarding the counter of 19,306, clause 6 is relevant. In the clause 6 of the counter, 19,306 writ petitions, clause 6, if you see, that there is mentioning that you are not suitable. Sir, actually, excluding merit, nothing can make me unsuitable for that post. And again, in
Para 7.
That's 6, sir. Here it is admitted, sir, in clause 6, sir, counter 19,306 of 2018. It is admitted that thereafter against the subsequent vacancies for the year 2016 and 17, such recruitment examination was conducted by the State Selection Board. So this is clearly mentioned 2016 and 17. These are accrued vacancies. And for such vacancies, I have eligibilities. And when I submitted the offline form, that was also rejected. And to mention here, also I have given in the reply that one of such case in a 12th in 11th December, order of this honorable court, one such case has been accepted, form has been accepted. I have mentioned, but I am eligible for 2016 and 17. That form should not have been rejected. Then I have approached this honorable court that to allow me for participation in 2018. That court, this honorable court has declined that order. I mean the interim applications, through which I am not able to participate in the 2018 examination, though I am eligible for 2016 and 17 vacancies. This is regarding the 19,306 counter. Now coming to the counter of the 2757, sir, clause, if you see, sir, clause 8, sir, clause 8 and clause 9, these are actually, if you see, sir, clause 5, the last one, out of total vacancies of 100, 99 candidates have been selected and one post has been issued. Sir, this is totally not acceptable. It is because the counter has been filed in 25th April, and by that time, the second council has not been conducted. Second council has been conducted in 7th July 2017. So the mentioning here that out of vacancies of 100, 99 candidates have been selected, that is not acceptable, sir. And then again in clause 8, sir, it is humbly submitted that the petitioners applied RTI Act 2015. Sir, if you see my annexure 53, 54 and 28, the rank provided to me is totally ambiguous. I have applied through RTI to know, because initially there is no merit. I have given a representation to Honorable Minister, to Principal Secretary, that since the recruitment process has conducted after a long gap, so therefore you make provision to make publishing merit list. Because I know many of such selected candidates, those have already been established with better offers. So I know that there will be vacancies, and since immediately on 21st August 2016, immediately after the result publications, I have given representation to the Honorable Minister and to Principal Secretary to make a merit list. And without making a merit list, the counseling was conducted, first counseling. So obviously the vacancies came up, and to those vacancies only counseling was conducted, second counseling only after my filing of the case 2757. That is on, again after a 10 month, the second counseling was conducted. On 7th July 2017, the second counseling was there. And his second counseling, there was vacancies, I mean there was non-joining cases. So as those non-joining cases I have annexed with annexure 3 to 7. And even there might have so many other cases of non-joining, which I might not have been able to collect also. So now, if you see to the clause 10.1, 10.2, 11.3 and 13.2 of the SSP Rule 1992, Odisha Education Act 1969. So the 11.3, that shows that the select list has to be valid for 1 year. So since the second counseling list has been published on 3rd July 2017, so again those list has to be valid to the next year. That means the accrued vacancies of the year 2016 and 17 should have been considered along with the non-joining cases, which has not been done by the SSB. Instead of doing that, sir, by annexure 21, you can see, sir, in annexure 20, you can see that government director of higher education have written a request letter that appoint guest lecturer against such vacancies. And instead of filling up these accrued vacancies and the cases of non-joining, the director of higher education has requested.
What do you say?
Melody, let's counter paragraph 6 and 7.
Right.
In the meantime, recruitment in response to advertisement number 3 of 2018, recruitment process is over and all the selected candidates have joined. Let's see paragraph 7 of my counter.
Right.
That in the meantime, the recruitment process as per advertisement 3 of 2018 has already been completed through the state selection board, and the selected candidates have already joined in the new assignment against the vacant section post in the non-government aided college. Since the candidates selected by the have already joined in the respective assignment, different non-government aided by efflux of the prayer made in the has gone infructuous.
No, what about his selection? Was he ever selected?
He was not selected in the first selection. After the completion of the first selection process, second advertisement was made in 2018. That you also can find it from Annexure 4. Annexure 5, my lord.
Yes.
You'll also see page 33.
Yes.
That was the subject matter of challenge in the present writ petition.
Right.
There you'll also see that the clause 3, page 36.
But I don't have the copy. I don't have the copy.
ଆପଣଙ୍କ ପିଟିସନରୁ ମୁଁ ପଢୁଛି ଆପଣଙ୍କ କପି କଣ
Reply from the repetition.
Let's see page 36 age limit.
Yes.
The age limit for the general category shall be 21 years and maximum age shall 42 years as on 1st September 2018. By that time, he has over that 42 years. So he could not qualify that age limit for which he could not appear in this selection test. So in the meantime, that 2015, the first selection of 2015, that has left and 2018 selection is completed. And he is saying that in view of that Annexure 6, that the upper age fixation of limitation rules, he has been deprived of to appear in the recruitment test as no relaxation of age is there. Because in 2016, his case is that in 2016-17, we have not conducted the recruitment test. So he was deprived of in appearing the test. In 2000, because we conducted 2018, by that time he has overage. So you'll also know that the condition stipulated in the advice that is binding to him. And we have not, because of various reasons, we have not conducted examination in 2016-17. And the vacancies of 2016-17, they are clubbed together and recruitment has been conducted in 2018. Once he does not qualify the terms and conditions of the advertisement, his case cannot be considered.
No, he says he's deprived of opportunities of appearing in those years where you did not conduct exam.
2006,
he might have got 3 attempts. Now he's got only 1 attempt.
Yes.
Had you conducted 2015 and 16,
we have
got 2 more attempts he could have got.
Yes, ma'am. His case is that because we have not conducted the examination in 2016 and 17, he has been deprived of his right to appear in the examination.
No, sir.
Unless we conduct the examination, the right to appear does not arise. And he has not a matter of right to appear in the examination unless we choose to select for filling of the post.
Yes. Yes, please.
Sir, 2016-17, there is no recruitment. Admitted it in the counter, they have admitted it is in their counter 6, in clause 6 of the counter. If you can see, sir, clause 6, they have written that thereafter against the subsequent vacancies for the year 2016 and 17, such recruitment was conducted. And 16 and 17, I am eligible. Sir, if you see to the Annexure 40, clause 8, clause 11, clause 13 and 19.
No
I have
exam was held, sir.
Sir?
No exam was held in 16 and 17.
Yes.
That is how, sir. Do know if it is a irregular process. Examination
can't be irregular. For nobody, across the board, must have those 2 years.
But
not only for you.
That is how, sir. Now I have appeared only 1 time.
Correct.
And even there are
that
candidates.
Is how they have the age relaxation and all that. Only to facilitate some of the older people to appear. That's why they had age relaxation.
And the original, if you see, sir, to the original petition actually, 2757, after the second counselling, there are non-joining cases which I have annexed in annex of 3.
Age is important, sir. Not about not joining. Age.
No, no, sir. I have appeared in 2015, which I am eligible. For that, second counseling has been conducted on 7th July 2017. After such second counseling, there are again cases of non-joining, which I have got from.
So you crossed the age of 42. You crossed it in 2017 itself.
43.
The problem with you, the age is coming in your way.
When sir, Odisha Civil Service offer is relaxation is given, and then why this is such a discrimination has to be there? And if you see, sir, the annex clauses, it is clearly mentioned that unless the commission has conducted selections, then vacancies for those cases, we must be provided with opportunity, sir.
All right.
And since that has not been considered, so I lost my opportunity and I have only appeared one time. And again, it is looking to the 2757.
Right.
Despite of so many non-joining, my representation has not been considered and my the list has not been exhausted.
All right. All right. Orders reserved.
Sir?
Supplementary list item number 89.
Yes. Sir, again.
Item 89.
My lord, the rejoinder I have filed through the counter affidavit filed by the opposite party number 8, who is the purchaser in this case. Kindly go to the page 28. Page 28 of my date application, my lord.
We'll list it for final hearing, sir.
Pardon?
Rejoinder has been handed over in court today.
Yes.
I have sought with the petitioner list for final hearing on February.
The matter was adjourned, my lord.
Yes.
Adjourned to 6th February.
And there is an interim order operating against me, my lord.
Yes, my interim order because they have
My lord.
they have purchased land.
So solve the copy, my lord. And my lord, today they have in the court, they have filed the rejoinder.
All right.
The interim order is operating against me.
All right. We'll have it on 14 December. 14 December.
Yes.
All right.
Item number 90.
May I please, Lordship? Lordship, on behalf of GM Sahu, Lordship, counter has not been filed.
I have one more opportunity to file a counter. And also for us,
It's a writ appeal. I don't know why counter is necessary.
there is no counter was filed before the single.
I see. Single judge, is it? I see. Last option to file counter affidavit within 8 weeks. Rejoinder before the next date. There will be no stay order, I think.
No. And also notice to go at a private property party there. Which part number 5 is the private.
They have not been served yet. No, valid service. 6.5 has been validly served. 7th February.
Lordship, 7th November.
Item date 7th February. Item 91.
91 the date. May I please your lordship? I am for the petitioner and the opposite party 5, 6 and 7 and enclosed open government land. And the order dated 4/8/2022 has been complied by the Tahsildar and we have complied the order. They have been evicted.
All right. See, in view of the subsequent developments, nothing further survives for consideration the present petition and it's disposed of as such. All right.
Supplementary list item 92.
Illegality has been misutilized in this millet. Your Lordship may kindly have a glance at construction of Panchayat Bhavan at Jalamundua Gram Panchayat.
You're not audible, sir. Pass over.
Supplementary item 93.
93 and 94
same,
at 2 p.m.
Some at 93 at 2 p.m. All right.
At 2 p.m. Along with that PIL. From.
Supplementary item 94.
Lordship, pardon to mention, Your Lordship, item 93 and 94, Your Lordship may take any other day, Your Lordship, Mr. Mahanti is there admitted in the hospital.
That's what I thought.
Yes,
Yesterday he was mentioning that. That even the 2 p.m. matter can't go on then.
At that time, Your Lordship can.
I will be there, Your Lordship.
All right.
93, 94 passes.
2 p.m. It is a Passover item.
Item 95.
95. Tomorrow, 95. That is also to be at 2 p.m. His case is 94. Oh?
Supplementary list item 95.
95 is criminal.
No.
It's criminal. PIL.
95 is PIL.
Sorry. I thought it is a criminal matter, Mr. Tholo is.
Anshuman Rai in person.
Please.
Yes, this is the case where last on 2nd of August. 2nd August, my lord, my lord's order number 4 on 2nd August.
This is that rare disease.
Yes, my lord.
The rare disease.
My lord. Here, my lord, though my lord was pleased to give last opportunity to Union of India to file their counter.
Correct. Yes, Mr. Pari.
Yes, already filed, my lord. Day before yesterday we have filed, copy also served, my lord. If my land not give it, I can give you another one also.
No, copy has not been served. I received the copy from the state government yesterday evening only. And you have not given copy.
Another copy, no issue. This Bobita Sahu is filed, he will give.
Yes, my lord. We fix up a short date the next week itself, my lord. Because it's a rare disease and my lord.
So we have already been adjourning it very quickly.
No, my lord, it was in the last 2nd August 2022. Today is my lord 15th September. So,
have you seen other repetitions? Has it? Have we?
Considering the gravity.
Have you been remiss in entertaining the petition?
No, my lord. Considering the gravity of the.
Have you not understood the gravity, sir?
So, my lord is adjourning to.
Where is your counter, sir? Mr. Padi, where is the counter?
It's already online. We have a hard copy, so we can file. We have a hard copy. We can also file, but online it was already filed yesterday.
I don't know. It's not here. See, the counter affidavit stated have been filed by Union of India be placed on record. What have you said there?
We have said that according to the Government of India plan, the national policy of the rare diseases 2021 scheme, we can provide the treatment.
Okay. So that's all we need.
No,
when will you provide? Now, when will you provide?
Last order, a memo has been filed today by me, my lord, memo, my lord, the order.
So when will you provide it, sir? That memo shown.
I have given my yes.
Can I copy?
The order passed by Delhi High Court.
Very expensive treatment, my lord. That's why the paragraph 5. We have
so Delhi High Court, there's already an order, very detailed order.
My lord. Let me see page 10 of the order.
It is better, my lord. Let's keep it to some other day. We can also physically we can appraise the court of it.
At least some interim will be made by Union of India to save.
No, but what has happened in Delhi? You tell us. We'll ask them to make the same arrangement.
My lord, we see the ordering person. Page 12, paragraph 9. On the last submission of Mr. Luthra, Mr. Oberoi would submit that AIMS is not in a position to utilize the annual budget sanctioned to the AIMS for the treatment of petitioners herein. He also states that insofar as the petitioners who are suffering from non-DMD disease, they can be directed to report to the chairman of rare diseases, Dr. Madhulika Kabra, day after tomorrow, on which date they shall be attended to and the treatment shall be started. I must state here that the submissions made by Mr. Oberoi are not at all appealing. The order passed on December 14, 2021 is very clear that the treatment of the petitioners, that the children must start immediately. It is surprising that even after a period of 1 month, no treatment has yet been started. Insofar as funds are concerned, the court in this said order has clearly stated that it is the responsibility of the Union of India to ensure necessary funds are provided to all centers of excellence, including AIMS, as and when demanded for treatment of these children. My Lord, in paragraph in, my Lord, third line, my Lord, will see, for starting the treatment of the petitioners, whichever petitioner approach such a center, being dearer to the place of residence without any delay. My Lord, here we have approached by 15 children have approached, my Lord. They are the residents of Orissa. Similar order we passed, my Lord, so that we will be in a
So who is in AIMS, Bhubaneswar, who can deal with them, sir? Give us a name. At 2 o'clock, we'll take it up. You give us a name. You also give us a hard copy of the counter affidavit. We'll take it up at 2 o'clock. And give us a name of the doctor in AIMS, Bhubaneswar, who can immediately deal with these patients.
Can it be tomorrow, my lord? Can it
All
be
right. At the request of Mr. P.K. Paddy, list tomorrow.
Yes,
All
sir.
right. All right. Meanwhile, the counter affidavit will be brought under and a copy be served on counsel for the petition. Yes.
Oh, my lord. Definitely.
Supplementary list, draft or matter item number
Pardon to
56.
mention, my lord. Pardon to mention, my lord. Item 48, my lord. Whenever your lordship call it, my lord, I have a lip problem. I have not attended to this court, my lord. Kindly taken up 1 week after.
No, tell us now. Wait.
I want some of the instruction of the client, my lord.
No.
Because that is a PL matter.
No, it's all right, sir. We'll see what the matter is about.
Tomorrow, my lord.
1 minute. Let's just see what the matter is about. Tosh Nayak. This is that medical store that is over, no? Mr. Manti?
Yes.
This is that medicine store or something. The tender
Yes,
is over already.
that is what I was thinking.
Tender is over already.
24/7 inside the medical campus.
That is over. The tender is over. That's what he says. That period is over. No?
My lord,
that practice is over. That
there is no longer a 24/7. That policy has been discontinued to have a 24/7.
My lord, that is already continuing, my lord. But that all the shop also continuing in this area, my lord. That is, I have
area is different. Sir. Inside the campus is another thing.
inside the campus.
Inside campus. That is the case, my lord. That is a PL, my lord.
No, I know.
Yes.
But since there are medicine shops available in the area 24/7, they're probably discontinuing it inside the campus.
So far as that policy is concerned, that is no more in vogue. All right, your lordship may direct me. I will take current instruction so far as the policy is concerned.
Yes,
all right. In 3119 of 2016, at the request of Mr. D.K. Monti, wants to take instructions. List on 19th December. All right.
19th December. Obliged.
Fast or matter item 56.
6 my lord. Just now I received a counter filed by the no 6 my lord. Let come next week, my lord. Waqf board, my lord. Where is it? Who's first responsible? Appointment of full-time chief executive officer of Odisha Board of Waqf, my lord. You're filing it today, sir? Yes. Yes. Reply has been handed over by counsel for respond number 6 today in court. Rejoinder, if any, be filed before the next date. List on 12th January.
Fast or matter item number 92. Item 92. Supplementary list item 92.
None appears. Let's try to pass it. Let's just for normal.
Oh, he had appeared, but there was some technical glitch.
Oh, he was there, is it?
It's not clear. No, it's not joined.
Huh?
Not joined it.
Số rồi hả? Đi tập đấy.
On the first call, Mr. Parida appeared in virtual mode, but because of a network issue at his end, he was not audible. On the second call, he does not appear. In the interest of justice, list on 18 January.
Hearing. For hearing item number 96.
May I please your lordship? Pursuant to your lordship's direction, contained in the order dated 21st July, all the 11 appellants have personally appeared. I have, on taking consent from the previous council, just a fortnight back I have appeared. So I request your lordship, so grant me a month time, so that in the meantime I will prepare the case and
Sir,
address
can't
you.
be adjourning like this, sir.
No, but just
whole point is that you can't go on adjourning, man.
No. I have just newly appointed by them, my lord. Your lordship may kindly just a fortnight back I have appeared. I have taken the paper book recently 2 days back. So let me prepare my 18 accused persons, my lord. I will prepare and I will address you.
2 and 18 have died.
2 and 18, right? Sir, a report has been submitted by IIC Golantara PS, stating that appellant numbers 2 and 18 have expired in the meanwhile. As regards the remaining 16 appellants,
some are on bail.
11 accused persons are on bail and 5 are in custody.
5 are still in custody and 11 are present in court today. You appear on behalf of all the 16.
My lord, I am appearing on behalf of 15 accused persons. I am for appellant number 10. And rest of the appellant I am appearing.
So and so appears for appellant number 10. And what is your name, sir?
Arun Kumar Acharya.
And Mr. Arun Kumar Acharya appears on behalf of the remaining appellants. Mr. Acharya states he needs to get ready with the matter. At his request list on 11th October. The appellants who are present in court need not remain present on the next date. All right.
Item 97.
In item number 97, my lord, I am appealing for all the appellants in both the appeals, my lord.
Yes.
Let the matter be listed after vacation, any date, my lord. Due to illness, I could not prepare my written notes. And let it come after vacation, any date may be fixed, my lord.
Counsel appearing for the appellant states that she is not prepared to argue the case today, as she is not prepared, as she is not ready with the matter. At her request, list on 18th October.
Obliged.
Yeah, follow.
Weekly list.
But in item number 3, I am ready. Item number 3.
Please start, sir. Start. Mr. Dale, you are ready in 1?
In 2, my lords. In item 2, my lords.
2?
Yeah.
You are ready?
I'm appearing for 2. If it by running train will do the case.
No, we don't want to. What happens is then you go and we don't want to be able to get you at all. You are a very rare commodity. So
No, but
we have to wait. You people are
appearing in.
We are permanent fixtures. So we have no other work.
I have argued number of cases before. I have already argued number of cases.
In the judges keep waiting. Hoping some lawyers will appear.
I have argued at least 3-4 cases before my life.
We are very obliged there. There's no difficulty. The problem is we have several cases. And we have to deal with all those several cases.
My lawyer thing, then
No, we don't want you to disappear. That's all we are saying.
I will be there.
Yes, Mr. Ajay.
Item 3.
May I please your lordship? My lord, this appellant has been convicted under section 302 and sentenced to imprisonment for life.
Yes.
The prosecution case, the law was set into motion on the basis of a written information by PW6, who is a doctor. He reported that one Jagdish Oram was admitted in the Central Hospital, Joda, on 8th June 1997, having some injury, 3 number of injury incised on his head.
Let's beg pardon.
And while
item 3 is not available. We'll take to buy a pen drive. I'm sorry, I'm very sorry.
He's fully ready. You've given him copies of this?
Yes, I have given it.
All right. You already got copies of this?
Yes. A very short thing, if your lordship can hear, or else. Otherwise, it will be taken up on Monday because after lunch, my lord, I have some.
What will happen? All right. Counsel for the state says he does not have the brief. He is permitted to collect a soft copy on a pen drive. And it will be called out. He will remain on board.
No, on Monday, my lord. Today
it will remain on board, sir.
Yes.
Nothing will happen to it. We'll call it out on.
And my lord, in item number 16, my lord.
Sir, which matters are you ready now? Which are you not, Mr. Katkia?
Yes, right.
We ask Mr. Dale to now come after he starts. Don't tell me you don't have his paper.
Mr. Dal, I'll be doing that matter. Item 2, I'm here.
Can you call Mr. Dale then? You can start.
In item number 16, my lord, I have information that one of the appellant is dead. If your lordship can direct the state council to obtain instruction.
One of the appellants, is it?
My lord, in item number 16, one of the appellant is dead. There are 3 appellants. I have information, but I'm not sure.
All right.
So let
him note down. Yes.
Item number 16.
I'll get into it.
234. 230.
Your lordships had asked me yesterday to take instruction regarding the appellants. All of them are alive.
All right.
Make to you, Lord.
Yes, please.
Here, ballot criminal appeal 259 of 86. I am appearing for appellant number 5 and 6. I am told that other appellants, they have already completed their submission.
Correct.
Ballot here is a case ballot 2 cases where they have 2 sessions trial, where they have ballot appellant number 5 has faced sessions trial number 36 by 11 by 160 of 96, 94 and 93 for offence under section 302, while appellant number 6 was placed under trial in ST number 10 by 18 by 4 by 424 of 96 by 94. Both the cases were clubbed and tried together. But ultimately charge was framed under section 302 read with 34 120B and section 32B and BI of ST and ST PA Act.
Right.
Here, my lord, the prosecution case is, my lord, as depicted under Exhibit 7, submitted by PW1 before the officer in charge, Banapur Police Station, and that is, my lord, before page.
Ravindra Swine and Kubera Jani is a servant.
My lord. Two persons have been killed, it is alleged. The affair was submitted before the officer in charge, PW 16. Received it, my lord, is not properly pressed bar. Before, my lord, officer in charge, Banapur Police Station, my lord, may kindly see page
82. You have to say that 10:30.
82.
That other matters. Tomorrow is Friday now.
Page 82.
For that first matter, that Ames matter.
Page 82 of the paperwork, my lord, may see.
Yes.
The column meant for the accused is unknown.
Right.
My lord, but subsequently affair has been registered where this formal affair is, my lord, Exhibit 1, and Exhibit 7 is the affair where 6 persons have been named, my lord. Initially, my lord, as judgment shows, around 30 persons were placed on the trial, but they have been acquitted because person who had named them conspiracy, he has not been examined, so they have been acquitted from the charge. But as per the allegation of PW1 before the officer in charge, Banapur Police Station, that in the morning of 16/9/91, his younger brother Ravindra Swani along with field servant Kuber Jani went to village Chaka Singh in search of a field servant. When they did not return till 5 p.m. on that day, the informant PW1 developed some suspicion in his mind, as there was previous village dispute in the village dispute between them. Accordingly, he, along with one Vijay Patnaik, PW4, and his nephew, Babu alias Birendra, who has not been examined, went towards village Chaka Singh through the Ghat Road of Valerie Hill. On their way to village Chaka Singh, they met Raja Baliyar Singh, PW3, near the foothill of Valerie Hillock. He asked them as to where they were going. PW1 told him that his brother Ravi had gone to village Chaka Singh. Since he has not returned, they are going to search him. At that time, Raja Baliyar Singh told that he had seen the appellants being armed with sword and khaki were going towards the village Chaka Singh 1 hour before. This news made the suspicion of the informant more graver. They also asked PW3 to accompany them. After covering around some distance, they heard the voice of the brother saying not to be killed. This is a case which is rest on circumstantial evidence. And prosecution has relied upon the evidence of PW1 and 3, mostly, my lord, and extrajudicial confession of PW8 to prove the case, my lord. My lord, here, my lord, they found that the appellants were coming down from the Ghat Road. Their wearing apparels were stained with blood. The appellants, having seen PW1 and his companions, ran away. After the departure of the appellant number 1 and his companions went in search of his brother. On the Ghat Road near Dalakhai Thakurani, they found the blood patches. And when they did not get any trace of their brother, PW1, then their field servant Kuber Jani, and they suspected that they had been killed. After returning to the police, I informed the APR force, APR constable, who has not been examined, about what they had seen, and as per their advice, he submitted the written report before PW16. My lord, PW16 on receipt of Exhibit 7 registered the case, investigated into the same, submitted charge sheet, and accordingly, my lord, the appellants and others were placed on a trial. To substantiate the allegation, my lord, the prosecution has examined around 18 witnesses, and PW 19, one PC Pradhan has been examined as a court witness. My lord,
yes,
the plea of the appellant was one of complete denial, and for the defense that they had been falsely implicated in the case due to previous enmity with the informant. My lord, there is no direct evidence in the instant case, and exactly, my lord, the case just on circumstantial evidence and principles with regards to circumstantial evidence beginning from 84 Supreme Court or 57 Supreme Court, my lord, till date, the same, my lord. There should be no missing link in the evidence, and the chain should be so strong that unerringly point to the guilt of the accused. My lord, here, first point which I want to say, my lord, PW1 is the informant in the present case, though in the body of the affair, PW1 has named 6 persons who we suspected the assailant to be the assailants of the deceased persons, but in the formal affair, my lord, that entertains a doubt in the mind that in the formal affair, in the column meant for the accused, it is mentioned that persons are unknown. If he had strong suspicion in the mind from the beginning, from the time he saw the accused persons, he would have mentioned that, yes, I have got strong suspicion that I have done with the life of my brother. In order to clarify that position, my lord, PW 16, the investigating officer, my lord, may kindly see para 30 of PW 16. Before going to the evidence of PW 16, my lord, may see the affair at page. Again, my lord, only for my lord's clarification, that then column 2 meant name and residence of the accused unknown. And this second page shows the name of the accused persons. And that question has been specifically put to PW 16. My lord may see the evidence of PW 16. That is at page 215, my lord. Sorry. That is at page 284.
yes.
Paragraph 30, my lord. Well, got it? Ballot. In the affair, it is disclosed. Ballot we see what 8th line, ballot. In the affair, it is disclosed by the informant that he had seen his brother Robbie and field servant Kubera in the morning of 16/9/91. Since the informant has specifically mentioned towards the last part of Exhibit 7 that the accused persons named therein have committed heinous murder Therefore, I registered the case under section 302 IPC. Read section 34 besides other provisions of law. In the formal affair exhibit 1, I have mentioned assailants to be unknown because the informant, though disclosed 6 names, had stated that he doubted their complicity. I drew up exhibit 1 after I registered PS case number 132 of 91. The ink used to draw exhibit 1 is different from the ink used in the endorsement in exhibit 7. It is not a fact that the informant lost a written affair in the morning of 17th September 1991, wherein he had indicated the assailants of his brother and field servant to be unknown persons, and that in that view of the affair, I have indicated in exhibit 1 that the assailants were unknown. That due to political pressure, the said affair was suppressed and hushed up and was replaced by exhibit 7. My lord, after that, he has stated, my lord, we'll see. Since the informant had categorically mentioned in exhibit 7 about the death of his brother, field servant, I recorded his exhibit 302, except the affair and the statements recorded from the informant. I had no other evidence before me till 9:30 a.m. of 17/9/91 as to who were the real assailants of the deceased. Relying upon affair exhibit 7 and the statement of the informant, I held that the accused persons named in the affair were the assailants. Before sending the dead bodies for postmortem examination, I had reduced the 6 persons named in the affair were the assailants deceased. There are no evidence before me till 9:30 a.m. of 17/9/91 that these 6 accused persons named in the affair had assaulted the deceased in exhibit. My lord, he further testified that these 6 accused persons named in the affair, my lord, it is, my lord, I want to submit, my lord, it is PW 16 is clear to the effect that PW 1, the informant, had not stated the names of the appellants in his affair, and from the cross-examination of IO, it transpires that the names of the appellants have been subsequently added with some oblique reason or ulterior motive, my lord.
Right.
Therefore, no reliance can be placed on this circumstance that immediately after the occurrence, the accused persons were seen near the foothill of Valerie Hill. It can also be inferred that the original affair has been suppressed by prosecution. Had the original version been treated as affair and produced during trial, my lord, the story narrated it could have been unfavorable to the prosecution. Therefore, it has been suppressed, my lord. By my humble submission before my lord is, therefore, it has been suppressed. It was banished that would not see the light of the day, and it has been held by this honorable court as well as by the apex court in number of cases, my lord. Beginning from 1990 Criminal Law Journal 1848 and 81 Supreme Court 1230. My lord, may I cite the decisions, my lord? Or
no, you can give us a note. I think that's fine.
My lord, I'll give you a note.
Right.
I finalize it and give it to you.
Right.
My lord. My lord, with regards to the evidence of PW3.
Yes.
My lord has seen that the evidence of PW1, initially, my lord, formal affair, the name of the accused persons were not there. Accused persons are unknown. Subsequently, exhibit 7 was registered where the name of the accused persons found place. IO has also candidly admitted in paragraph 30 of his cross-examination about the same.
Yes.
Specific questions have been put and he has also answered that.
Right.
My lord, we see the evidence of PW3. As per evidence of PW1, on the way he made PW3. And my lord, Law and Trial Court has believed PW3 bereft of the fact that my lord, PW3 has candidly admitted that he had strong animosity. What PW3 has said, he accompanied with PW1 to a particular place and saw the accused persons are returning. And court has believed, without any corroboration to that evidence, though he has admitted by in his evidence that he had strong animosity with the other group of the village, for which a case under section 107 is pending. A PS case ballot of 68 of 80 is also pending between them. And in that respect, my humble submission is, court can believe a witness, but if a witness has got sort of inimical relationship with the accused persons, that evidence requires corroboration. It will not be discarded. I will not submit that, but it will be discarded as it is. It requires due corroboration. But prosecution has not adduced any evidence to say that PW3 was also there. I was also there with PW3, and I have seen also this fact. Evidence of PW5, he says, before the court that on the date of occurrence, he had gone to the field to manure. He also been brought by the prosecution that he was manuring the land in question in the village, and he saw PW1, and he saw the accused persons while they were going to the hill. But neither this PW5 has informed PW1 about the same, or the APR force, those who are, because of the village dispute, APR force was there in the village. Neither he has informed this fact to PW1 or to the APR force about conduct of accused persons. Nothing is there, ballot. And when this point was raised by the counsel appearing for the accused persons in the lower court said, you have not brought out any sort of enmity with him, why he will be disbelieved? Again, my lord, the same answer, my lord, 81 Supreme Court 765, Shankarlal Gaislal Likit versus State of Maharashtra, wherein the Honorable Apex Court has been pleased to observe that mysterious is the working of human mind. My lord, why he has come? Because he belongs to the other group. It is not natural. How can we say that why he has deposed against us, my lord? And he has been believed by the trial court on that score itself, my lord. My lord, with regards to the evidence of PW7, who was deposed to the effect that he had gone to Vikari Behera with Vikari Behera and Satya Behera for easing in a place near Foothill of Bellery on the date of occurrence, and he found there 6 accused persons sitting together at one place and discussing something. When they passed by their side, accused Sasadeva and Vasudev were saying that even if some settlement of dispute with the village will be reached, they will kill the deceased persons and play football with their heads. That he had stated, he has deposed before the court, but it is pertinent to mention here, my lord, that PW7 had not informed PW9 and the deceased about the threat given by the accused Vasudev or Sasadev, my lord. Vasudev is here appellant number 6, Sasadev is appellant number. So PW7 has also disclosed this fact to APR force, which is quite natural on the part of PW7 to have passed this disturbing message, because if he had seen the accused persons there, what made him not to disclose? When the witness, those who are belongs to the petty faction in the village is there, admittedly that animosity is there. So when he had heard something or he has seen something, he would have, it is but natural that he will disclose it before the person comes, because they have taken the name of the deceased. So he would have said it to PW1 or to the APR force, but he has not done so. But another circumstance prosecution has relied upon, the alleged extrajudicial confession made before PW8 by all the accused persons at a time. And peculiarity is this PW8 has stated so for the first time in the court, and it has been the attention of PW16 has been drawn about the same, and PW16, the investigating officer has candidly admitted that PW8 has not stated about this extrajudicial confession for me. And he has stated for the first time before the court that I asked the accused persons about the same, and they jointly stated before, that is, joint statement is also inadmissible. They jointly stated before me that they have killed. That is
inadmissible anyway.
Ballot.
That is inadmissible anyway.
That is inadmissible ballot. And not acceptable in the sense ballot. He had also not stated so before the police. And that too, the rules with regards to pertaining to extrajudicial confession is different ballot.
Yes.
Another most important thing, my lord, which goes to the root of the case about the time of occurrence, my lord. On a conjoint reading of evidence of PW 1, 3, 5, and 7, it will be seen, my lord, that PW 1 says that I, being apprehensive about the absence of or the return of my brother at around 5 p.m., I left for Valerie Hills. And PW 4 ballot, if the evidence will be seen, it will be seen that around 1.5 hours to reach Valerie Hill from the village. Why I'm saying so, my lord, I will draw my lord's attention to that. And he says, on the way, I met PW3, who was in his brinjal field. And PW3 says, he had made the accused around 5 p.m. while they were returning. And doctor says, my lord,
time of death.
Yes, doctor says, my lord, if the statement of PW 1 and 3 will be believed, because one says, I met PW 3, PW 3 says they were returning at this time. So occurrence must have been taking place by 5 p.m. Well, let me see the evidence of doctor PW 15. Doctor is by Dr. Dayanidhi Jana, 280. Ballot, we'll see paragraph 6.
Page, till it's the running page?
Running page is ballot 52.
252.
Sorry, 282. 282. It's not visible. 282.
Right.
Although it is a fact that I have not mentioned that the injuries on Kubera and Ravindra were antemortem in nature in exhibit 17 and 18, yet it is quite apparent that they are so. I have not examined the blood clots and the injuries found in both the cases for chemical analysis to find out if such blood clots were antemortem or postmortem in nature. After 12 hours of the death and within 18 hours, green discoloration of the abdomen will appear. Well, let me kindly take note of it. After 12 hours of the death and within 18 hours, green discoloration of the abdomen will appear. In this case, I have not noticed any such coloration. Within 12 to 24 hours of the time of death, the whole body will undergo green discoloration. After 12 hours of the death, the abdomen will be distended due to accumulation of gas. I have not found the abdomen to have been distended in both the cases. Here, my lord, the postmortem examination has been conducted
17.
on 17th at 2 p.m. My lord, very, very important, my lord, that goes to the root, my lord. occurrence has taken place, 2 persons have been killed, but who are the authors of the crime? For that, my lord, may we see, he has conducted the postmortem examinations under Exhibit 17 and 18
of both the deceased.
At 1:45 p.m. and other at 2 p.m. on 17/9/91. Let me just visualize. Occurrence has taken place at 5 p.m. Say, well, he says again, my lord, I'm cost of repetition. I'm repeating. After 12 hours of the death of the abdomen, the abdomen will be distended due to accumulation of gas. I have not found the abdomen to have been distended in both the cases. So it is not the my lord, the case of prosecution that occurrence has taken place at midnight. I have not found the abdomen to have been distended in both the cases. In both the cases, I found rigor mortis is present. I have not indicated the degree of rigor mortis. The degree of rigor mortis gives an indication of the time of death. The breadth of MO1, that is not important. Well, I just wanted to bring my lord's notice that this is a case which rests on circumstantial evidence, my lord. And the case which is rests on circumstantial evidence, my lord, 84 Supreme Court 1622, Sharad Birchand versus State of Maharashtra, my lord,
yes,
has referred, my lord. I have gone through an argument. By going through an argument developed by my lord in Delhi High Court, that my lord has also taken note of 84 Supreme Court 1622.
Right.
And
that's a locus classicus.
my lord, therein, my lord, 5 Panchashil principles have been depicted.
Correct.
And if that rule will be followed strictly, my lord, there are a number of missing links, my lord. The chains are knots are not tied in such a fashion that there will be no other way but to reach a conclusion that these accused persons are the authors of the crime.
Right.
Or unerringly pointing to the guilt of the accused.
Right.
And again, just rely in that judgment itself, 84 Supreme Court 1622, my lord will see, they have also taken note of another golden rule of principle which usually follow in criminal law. My lord, the fouler of the crime had the proof, my lord. Here the case where, my lord, 6 persons have been convicted under section 302, including my appellants, my lord. They have been convicted for section 302 and sentenced to undergo rigorous imprisonment for life. And one, what I asserted, my lord, day before yesterday, my lord, one is 82 years old and other is 75 or 76 years old. My lord, again, my lord, I'm repeating, my lord, circumstantial evidence and circumstances prosecution has said evidence of PW 1, 3, 5, 7, and 8. My lord has said, yes, 8 extrajudicial confession cannot be taken note of because joint statement before the police, and that too he had not stated earlier in 161 before the police about the extrajudicial confession. But with regards to that PW 1, my lord, the affair, the original affair has not seen the light of the day. 81, my lord, my lord, I have given the reference in my note. I will give the reference also. 81 Supreme Court that has been relied upon till date, my lord, that it's a case where the prosecution is going to make allegation for offense under section 302. It's not a thing, my lord, where in case of 323 or 324, something will be changed, this thing, that thing, my lord. Here, police has also admitted that by 9 a.m. on the date of lodging of affair, I was not aware of the fact that who are the accused persons, because initially in the formal affair, it was unknown. Exhibit 1 is unknown. And in Exhibit 7, the names of 6 accused persons are coming out for the first time.
And with this, you're repeating yourself, Mr. Das.
Yes, I'm repeating because, well, that has got relevance to this for the decision of the case, well.
I know.
And
for emphasis.
For emphasis, well, yes, for emphasis. Well, another judgment which I am referring, well, that is 73 Supreme Court 773, which deals with one golden thread which runs through the administration of criminal justice is that if 2 views are possible,
one favoring
on the relevant,
One favoring the accused must be preferred. Yes.
That is the question.
Right.
I will give the references, my lord.
All right. We can start after lunch.
My lord.
Matter fixed for 2 p.m. Supplementary item E7.
May I please, Your Lordship? Lordship, may I have a glance at last order, para 4. There was a direction to the Puri collector. In pursuance of that direction, we have filed the affidavit. First, Your Lordship may kindly have a look over the affidavit of the Puri collector. Collector Puri is also there, I think.
Mr. Verma?
Sir, good afternoon.
Good afternoon.
Yes. This is the affidavit dated 13th September 2020. Page 2, paragraph 3 may kindly be seen.
Right.
The so many affairs have been lodged and there are still patrolling and cases have been registered against the defaulters.
All right.
Adequate police personnel are also engaged, and the RI and deputy RI, they have been suspended.
Right.
But in fact, the Tehsildar has also been transferred, sir. So we have a new Tehsildar.
The
Tehsildar is also
main
also
problem was with the Tehsildar.
he is already transferred. He's already.
Lordship, in this case, the persons those who have been arrested, they are belonging to the fisherman category, Lordship. They are doing it.
So
they are the persons.
Maybe.
Name is one Gopal and another is Abhimanyu Behera. Have done 5 acres. That they have demolished. It is the fisherman community, they are doing it. That is to be implemented. We want that should be implemented.
All right.
Lordship, the age-old tradition was there.
1 minute, please. Mr. Verma, the patrolling is continuing.
Yes, sir. Continuous patrolling is there, sir. The helpline number is also functional, sir.
Okay.
And we have made 13 FIR, 7 arrests in the past 1.5 months.
All right. You see,
the details have been.
My lord, I would request the learned court master to just kindly show some photos. The work is going on now.
We have also given a pen drive.
Around 700 to 800 illegal ponds were detected, which we have supplied to them. And they are doing it, but it will take time and it should be done in a very professional manner. If your lordship may see, actually the lake has been cut. It has been divided through this illegal earthengeries.
Oh, I see.
So there are around 700 to 800 ponds have been created. So it will take.
I think this.
Your lordship may see the sandbags. It's not possible for one person or 2 or 10, hundreds of persons get.
Lordship, these earthengeries are meant for protecting the villages from the high tide waters. The high tide waters are entering into the villages. Unless the earthengeries will be there, the villages that will be submerged in the water. That is why, that is the on the cost of the higher irrigation department, these earthengeries are constructed across Chilika, Lordship. Thousands of crores of rupees have been spent, Lordship.
1 minute, sir. Mr. Verma, what is your reaction to this?
Sir, basically, currently, sir, since the Chilka provides us with a vessel-mounted JCB machine, sir, which is able to do the net gary evictions properly, sir. So in the past 1 year or so, the prevalence of net garies has come down significantly, sir. I think the amicus query will also agree to that, sir. The more the problem area is the earthengeries, sir. Where during the rainy season, sir, because the Chilka provided vessel mounted JCB requires sufficient depth of water, it cannot reach out to these areas, sir. So we need to approach these areas from the land side, sir. And in rainy season, sir, because it's a lot of muddy water, etc., sir. So deployment of large amount of trees, sir, is not practically possible. So we do it manually, sir. So we have also requested for porcelain mounted, porcelain enabled machines, sir, which have these conveyor belt like tires, sir. So we will deploy them, sir. Sir, but it requires a large amount of manpower and funds, sir, which we will use from the protection of revenue land funds. So it is going on, sir, but it is a continuous process, sir.
Yeah, because this could not have come overnight. I mean, this we are looking at embankments like this. How this cannot happen overnight. This requires several hours and days of work. So unchecked, undetected.
Sir, after your direction last time, sir, the ADM had conducted an inquiry and found the RI and ARI to be at fault, sir. So we have suspended them, sir, and also got the tehsildar transferred out and a new one is in place.
Lordship, in this case, the main issues has not been addressed. Your Lordship has a glance to your Lordship's order on 4th April. Just have a glance your Lordship order on 4th April 2022. That is at paragraph 9, Lordship. Just have a glance your Lordship's order. 4th April 2022 order, Lordship. Your Lordship got it? 4th April 2022 Lordship. May I read Lordship, your Lordship's order?
Yes, yes.
It appears that although the applicant society is a that is pertaining to a society, next to that, Lordship, I am reading the whole paragraph 9. It appears that although the applicant society is a restored society, it has no formal permission from the competent authority to carry on any fishing activities. It is also plain that after 18th June 1999, no such permission has been granted to any PFCS, including the applicants. Consequently, the question of permitting the applicant to continue with its fishing activity does not arise. Considering the plea of the applicant society that earlier there was a policy by the state concerning traditional non-fishermen, a direction is issued to the Chilika Development Authority to examine the entire issue and submit a recommendation to the state government within a period of 3 months from the state government to consider whether any such policy needs to be reformulated consistent with the judgment of the Supreme Court and the prevailing legal regime. It will be open to the applicant society to make its submissions and representations to the Chilka Development Authority, which will give them a hearing on a mutually convenient date. Lordship, this is pertaining to formulation of policy. Lordship, what is happening in this case? What the earthen garage, what they are destroying right now, it is not only in Puri, in Ganjam, in Khordha also. These earthen garages are constructed on the cost of the higher irrigation department, Lordship. London government advocate may seek the instruction. How much of crores rupees they have spent for formulating this earthen garage. These earthen garages has been constructed across Chilka to check the tide water not to enter into the...
Sorry, I'm not able to understand how one department can take upon itself.
Your Lordship's order, they have to carry it out.
No. 1 minute. About constructing these earthen garages, if this is within the no-go zone, when we should call it a no-go zone.
Lordship, what is happening?
You guys can't, without consulting other departments.
In the rainy season, the water and submerging the areas.
It's not the summer season. Water is sitting thousands of years, sir.
Our issue is that why they are destroying this
thousands of years. These garages have come up recently. And they are not formulating any policy. Lordship's direction is there. The villagers there know how to deal with any climate change or even all this kind of tidal waves. They know how to
Lordship, that's we need. That's we require, Lordship. Villagers' involvement should be there. It is only the communities when they will be involved. They can very well protect the environment of Chilka.
No, but in the pretext of trying to protect the villagers, you can't have illegal garages. Corrected, earthen garages.
Lordship, that is why we demand, all these people across Chilka, they demand a policy to be formulated. That is the direction from the 99 also. Till date, there are 4 times this kind of direction has been given by the honorable courts.
What has happened in this direction, Mr.
My Lord,
they are not formulating that policy.
So far as that direction is concerned, it is to be complied by the Chilika Development Authority. So, and they are the export bodies.
You are appearing or somebody was appearing, no, for CDA?
No, I was not appearing.
Somebody is appearing. Mr. Mr. Mahapatri was, but now government is taking instruction all for CDA is concerned. That's why he's not appearing, Lordship. Now the state government, they're giving information.
My Lord, in fact, my Lord, there was a direction to the state government earlier in 2011 by this honorable court. I am appearing for OP 15, my Lord, non-fishermen cooperative society, one of the societies, my Lord. There was a direction from this honorable court to consider and frame a policy taking into view the interest of both fishermen and non-fishermen community, my Lord. We are not going against demolition. We are not defending illegal gheris, my lord. The only thing, every problem arises out of the policy, my lord. That is
we've already issued the direction.
what I suggest, my lord, humbly, if I could pray before your lordship is, lordship can ask the state government to give its suggestions before your lordship only. For the policy.
You ask the CDA to come up with the policy because the CDA is the one who has to.
Lordship, in fact, subject to correction, lordship. In fact, lordship, all these chilicas coming under the revenue department, not under the CDA.
Not under CDA.
For the first time for demolition and this purpose, CDA has come to play, lordship. So if lordship direct to state government, it will be better to obtain instruction because the revenue department is the only authority.
No. So far as the compliance by CDA is concerned, it is to be complied by the CDA itself. If your lordship will direct me, then I will take instruction from CDA. But CDA.
No, that order is there, but the revenue department is the company to make a policy, not the CDA.
Order is
private body, government.
That order is to be complied by the CDA. So it is a specialized body having its own entity. So
lordship, kindly tag one rate application that 9014/14 lordship. Where that that rate application, your lordship is given specific direction to formulate a policy. That is still pending. Batch of rate application still pending before this honorable court.
Orders.
Government has been given a specific direction to form a policy, and they have given a statement. They have framed the policy, and it is pending after approval of the cabinet. It has gone to the select committee since 2014 lordship. So still it is pending. If that will work out, it will be a permanent solution. It will give a light of the lordship.
Yes,
entire issue.
Because I know that was an order of the Honorable Supreme Court. So if lordship can, because once that is framed, then every problem will be solved.
Yes, my lord.
Anyway, you see, pursuant to the directions issued by this court in its order dated 11th August 2022, as regards the illegal gheris in the Patanasi area of Krishna Prasad Tehsil, a detailed affidavit has been filed by the Collector Puri on 13th September 2022, inter alia pointing out that as many as 13 FIRs have been registered and several illegal net gheris have been dismantled. Full stop. He points out that the revenue inspector and assistant revenue inspector of Krishna Prasad Tehsil have been placed under suspension by an order dated 17th August 2022. And the Tehsildar has also been transferred. Full stop. Mr. Verma, the Collector Puri, who has appeared in virtual mode, assures the court that intense patrolling of the area is being undertaken and every effort is being made to ensure that there's no re-emergence of the already dismantled illegal net gheris. Paragraph.
My lord, may I
Mohit
submit
Agarwal
one?
and amicus curiae drew the attention of the court to photographs showing earthen gheris having come up in several areas in Chilika Lake, thereby creating artificial ponds where the same illegal raw gheris could become operational. Full stop. Mr. Verma states that he will examine each of these instances and deploy additional manpower to ensure that even the unauthorized earthen gheris are dismantled. Full stop. A further affidavit in this regard be filed by Mr. Verma before the next date.
My lord, may I submit one? We have given a pen drive showing the massive demolition operation in the last 2nd and 3rd September. Your lordship may kindly note it.
You transfer the Tahsildar. God bless you. On one hand, you are saying you transfer the Tahsildar, and another is saying, or his negligence of this going on. Basic points.
This one.
Manually, we are doing it because all these are earthen gheris. This JCB is being used wherever required.
But entire thing should be cleared
Demolished.
in a professional manner.
It is only a glimpse.
Yes,
It is. Don't. If we will show the entire, then the entire day will.
Next Tahsildar should not repeat this.
This Tahsildar is very sincere Tahsildar we have appointed.
Exchange of water is the most essential thing for the lake to survive.
You see
The
how the
ecosystem.
water is flowing from one side to another.
It flows continuously.
Everything is transparent. Only
Cultivation in the natural process, Lordship, will not cause any ecological hazards to the Chilka Lake, Lordship. It is only the polythene
You say the code
and
has also been shown
that will causing
video clips
pollution to the Chilka water.
on the side of the collector Puri about the action taken to remove some part of the earthen gheries as well. Full stop. What about that?
Then your loss
Paranine?
may come
Alright.
to Kendrapada.
You say, as regards the direction issued by this court to the Chilika Development Authority. Today, nobody is appearing for CDA.
Lordship.
CDA.
Chilika Development Authority in the order dated 4th April 2022 that a policy should be formulated for traditional non-fishermen. There is no response as yet filed by the CDA. Full stop. It was suggested on behalf of the petitioners, some of the petitioners represented by Mr. Dalai, that maybe the revenue department should also be involved in the formulation of such policy. Full stop. Since this court was at that point in time informed that it would be the CDA which would be best suited to examine the entire issue objectively and submit recommendations to the state government. Those directions were issued. Full stop. The ultimate object is to have a policy formulated to cater to the demands of the traditional non-fishermen operating in the area. Full stop. The court would like to reiterate its directions issued in para 9 of its order dated 4th April 2022 and directs that in addition to the CDA, the state government will also,
in the Department of Revenue,
will examine the entire issue and perhaps collectively in consultation with the CDA, present a policy before the court within a period of 2 months from today.
Yes.
What about
Lordship, only Lordship में are non-fishermen and fishermen, Lordship, both the community, Lordship.
Sorry?
Non-fishermen, fishermen for both the communities, Lordship.
Non-traditional fishermen and non-fishermen. All right.
Yes.
Traditional non-fishermen and fishermen.
All
And
stakeholders.
all stakeholders. All stakeholders.
What about this Rajkanika Tehsil?
Yes, Kendrapada. Yes. We have filed the affidavit. Your Lordship have a. That affidavit is 17th August 2022. Affidavit filed by Rajendra Kumar Acharya, Deputy Collector Revenue, Kendrapada. Para 3, may kindly see. That by order dated so-and-so, this Honorable Court had directed the Collector Kendrapada to demolish the 3 sides of the wall instead of only one side of the pond of village, Tandaipur and so-and-so Tahsil, and further directed the collector to re-verify so-and-so has not been removed. That in obedience to the directions of this Honorable Court, it is submitted that FIR number so-and-so in Rajnagar PS has been lodged against Sri Pratap Kumar Khandwala of village Bharhanpur for unauthorized construction of illegal prawn gheries in Rakhit Khata number so-and-so, Mauja Tardeipur, and said person has been arrested. As per the directions of the Honorable Court, 4 sides of the embankment have been completely demolished.
To label this.
Para 5 at page 2 of my affidavit.
Yes.
Yes. That in obedience to the directions of this honorable.
We read that. We read that.
And we have completely demolished. That is our affidavit from all the sides, 4 sides. The deponent craves leaves of this honorable.
Okay. As regards the Rajkanika Tehsil, Kendrapada, an affidavit has been filed by the collector, Kendrapada, on 17th August 2022, confirming that all 4 sites of the illegally erected prawn gharry has been demolished. In village Saradepur of Rajnagar Tehsil has been completely demolished, and an FIR has also been registered in that regard. So stop. It is
para
stated in
5
affidavit that there is no re-emergence of the
53 numbers of prawn gharries
had been demolished. But there was some remaining to be demolished after monsoon season is over. That's not yet done.
And so far as 53 numbers which your lordship has pointed out in the last order, though
that has not re-emerged. No, but there are many more left still. See, 319.67 decimal was the total area of illegal gharries, and 282 had been demolished. And he had said that the rest would be demolished after the monsoon season.
Yes, that is the report.
A further affidavit about the removal of the remaining prawn gharries over an area of open bracket 319.67 minus 282.14 be filed at the court before the next date. Deputy Collector, not Collector. Deputy Collector Kendrapada. Then water quality testing. Who's appearing for the
pursuant to my lord's order, my lord, we have filed the affidavit. Affidavit is flag 197. Both Chilika and Bhitarkanika.
Now, what is your finding?
Finding with so far, my lord, for finding is concerned, my lord, it is within the class D specified standard. So far, the Bhitarkanika is concerned, and my lord, and Chilika is concerned, my lord. And suggestion have been given for improvement at paragraph 12.
No, total suspended solid contents in the water sample at all must show significantly higher concentration.
So suspended, lordship kindly see, so far the Chilika, Bhitarkanika is concerned, the lordship may took 13. Here the water quality specification is mentioned on the right hand side. Total suspended, there is no limit, not specified.
Okay.
As per the standard.
Anyway, if you want to examine it in detail, let us know.
But in respect of
and so for the suggestion for improvement, my lord, we have given at paragraph 12, we have given the steps to be taken.
All right.
For Chilika, my lord, at page 18, if your lordship may see, second last row, the fecal coliform, that is the most important pollutant. That is 3,300 at Bhusandipur, where the lake starts, and the limit should be 100 or less.
You see, the State Pollution Control Board Odisha has filed an affidavit
and
on 11 September 2022 regarding the
also online, my lord,
quality of the water, both at Chilika as well as Bhitarkanika. Enclosing with the affidavit the data of the test results. We'll stop. In para 12 of this affidavit, suggestions for improving the quality of water in both water bodies have been set out. Full stop. The state government will examine these suggestions and ensure that they are implemented in letter and spirit. Full stop. The amicus curiae will also further study the affidavit and suggest if any further directions are required in this regard on the next date.
Copy of that report may be handed over to me. Because no.
At flag 3, since the
my lord, person to my lord, sort of, my lord, the secretary also is online.
Correct.
My lord, since the secretary is online, I had already given a suggestion at flag 3. Now, what happens is that the water of river Daya that drains into the Chilika Lake. Now, there is a drain called Gangwa Nala that's of length of 35 kilometers, and all the untreated water of Bhubaneswar flows through that Nala into Daya River, and Daya River's water falls into Chilika Lake. So, at the point where Gangwa Nala discharges water into Daya River, it has to be treated there. And the state government had also contacted the NEERI New Delhi in 2015 to how to treat that water. So unless you treat it, and
yes,
so what secretary can explain?
Yes, sir. Please come in. What's his name?
Good afternoon, sir. This is Murugesan, sir. I am Murugesan.
Yes, Mr. Murugesan.
Murugesan, sir. Member Secretary, State Pollution Control Board, sir. So, as per the Honorable Court, sir, we had did test in both in Bhitarkanika as well as in Chilika. In Bhitarkanika, sir, its main purpose is meant for the wildlife and fisheries, and which is coming under the class D, and some extent people are also using it for drinking water purpose, so class C. So it is meeting the purpose. So only as your sir, you have mentioned that it is the total suspended particles are very high. It is because of the turbidity, because this is a rainy season. So there is a lot of solid materials are flowing inside the water. So that is the reason, sir. In case of Chilika, sir, Chilika, it is meant for the quality of D. It is mainly meant for the fisheries and wildlife purpose. So it is meeting the requirement. Whereas in SW2 category, which is also meant for the some sports activities as well as fishing and bathing. So there, the fecal coliform, which is mainly from the excreta of the human beings as well as the animals, though they must be going, they are the more than the level. So there are three places, that is on Bushandarpur and Mangalajodi and Kalpadagat. These three places only, they are on a slightly higher level. So because of the surroundings, there are settlements are there. So they have to be treated. Otherwise, they must have a separate septic tank so that this untreated septic water will not enter into the lake, sir.
Lordship, may I permit it with the Lordship permission? So far as the Bhushandpur, Mangalajodi and Kalpudaghat are concerned, Lordship, for about this treatment of the Chilka water, Lordship, this water body is being polluted naturally and also keep being cleared by the naturally. Nowadays, what is happening? All those parts covered by the mountain, that mountain range water that fallen into that part, Bhushandpur, Mangalajodi and Kalupada. All those range as mountain range. That is the reason why that water falling into the Chilka, Lordship. What is happening from Mangalajodi point, Chilika is after 8 kilometers. No boat can be pliable without the support of propelling machine boat into the deep Chilka, Lordship, because it is almost covered by this muddy water. It is completely muddy. But nowadays, only for 4 months, somebody can ply the machine boat conveniently from Mangalajodi or from Bhushandpur point to mid Chilka, the Chilka where the machine boat can be plied conveniently, Lordship. In case what is happening, Lordship, about this treatment of water, what I am proposing with your Lordship, with the permission, with the department officers are there. If at all we are all interested for making Chilka a environmentally free zone area, Lordship, why we are not involving the department, Lordship, for plantation of the coconut plantation across that area? It is thousands of acres of land are remain vacant without any kind of cultivation, this fish or any kind of.
But we are right now talking of the quality of the water. Please.
Lordship, I am addressing to that issue also.
Let him finish, sir. Then we can. You are just butting in. He has not even finished.
Lordship, it is community involvement that can clean the water.
Yes, Mr. Murugesan. No, the point is about that
Gangwa Nala, which drains,
which is drained there. What is your suggestion on that?
Sir, Gangwa Nala, sir, which is passing after it's a Nala, branch outping from the Kuakai River. It is passing through the entire city, Bhubaneswar city, and finally it falls into the Daya River. At present, sir, at 4 places, the state government, the Housing and Urban Development Department, they have constructed STP, sir, in massive number, and they are already, there is a separate committee also formed under the chairmanship of Chief Secretary. It is being reviewed every alternate months also, sir. So we are STP has been constructed, but it is not fully being operational because the connectivity problem is facing problem. So at present, the state government, the Housing and Urban Development is managing with the septic treatment plant. 2 places in Bhubaneswar, they are managing the septic water. Recently also, sir, the meeting was conducted and the Bhubaneswar Municipal Corporation, they are along with the State Pollution Control Board, we are identifying which are the main apartments or the big buildings which are releasing the untreated water into them and to take action, sir. It is in the already we are taking action.
No, that is remedial. No, that is remedial action, sir, is one thing. Preventive action is the other. So how are you ensuring that untreated effluent doesn't enter Daya River?
Sir, untreated, that is the only, sir, the preventive measure or the remedial measure is to only to go for sewage treatment plant. So sewage treatment plant has been already constructed, sir. Sufficient number it has been constructed. It is already, the case is also pending with the national.
No, but have you undertaken any testing of the Gangwa Nala water? At the point at which it enters Daya, is it acceptable level, not acceptable level?
Sir, this also, sir, Honorable Court, sir, about 4 months also we had discussion about this Gangwa Nala, similarly in the Mahanadi.
Correct,
sir,
correct.
Both the places, sir, I accept that the quality of the water is not up to the standard, sir. It is the both sir, that is there, sir. But the state government is also initiating. So it may take time, sir. Within the state government also is saying that within 4 or 5 months, once the full connectivity is there, all the septic tanks undertaking action against those people who are already releasing money, ensuring that they release only the treated water into the Nala, then the situation will improve, sir.
Where is Mr. Monty? Is there? Again, it comes back to state government.
Yes.
Then we have to find a solution, sir. We can't keep passing the buck, no?
No, we'll have a.
We asked the State Pollution Control Board for suggestions. Suggestions have to be acted upon.
Yes, we'll have a joint meeting with the State Pollution Control Board and to resolve the dispute.
You say, as regards the no, you say the learned amicus curiae has pointed out that one contributor to the discharge of untreated effluent into the Chilika Lake is the Gangwa Nala, which connects the Guakai River to the Daya River, flowing through Bhubaneswar city, and which Daya River ultimately drains into the Chilika Lake. Full stop. The point at which the Gangwa Nala drains into the Daya River has water of not acceptable quality, even according to the State Pollution Control Board, whose secretary, Mr. Murugesan, was present in virtual mode at today's hearing. Full stop. He states that although there are sufficient sewage treatment plants erected, these have to be properly integrated, correct?
Yes, sir.
For effective results to ensue. Stop. That requires concerted action of the state government. Stop. Mr. D.K. Mohanty, an additional government advocate, states that the state government will hold consultative meetings with not only the State Pollution Control Board, but also the resident welfare associations.
Yes.
Which may be discharging untreated effluent from their premises into the Gangwa Nala.
And your lordship may add BMC because BMC is also involved in
as well as Bhubaneswar Municipal Corporation.
Yes.
Stop. The outcome of these deliberations will be placed before the court along with an affidavit by the state government before the next date. Which are the other issues?
I have filed your lordship, pardon me, flag 199.
Whom are you first, sir?
I am one of the interveners, my lord. My intervention petition was allowed concerning fish farming, that prawn farming we were involved with, our intervention was allowed like 75 was the application. What has happened, my lord, if your lordship would look at my lord's order on 4/2022, at paragraph 14, my lords are directed. May I place that particular paragraph?
The district level committee.
Yes. That they will dispose of our application within 4 weeks from that date, my lord. In the meantime, my lord, may kindly look at 199, flag 199.
Right.
In the meantime, though the authorities have found that we have not violated any of the norm, and in fact, there is an acknowledgement also at flag 8, that is a letter dated 12/1/2022, to the effect that it is to inform that the registration certificate of your farm will be issued after placing the authority during the ensuing authority meeting for its approval. Yes. In principle, they have accepted my application, but till date, I have not received the approval, my lord, and the license. So I have come up before the 6 or 7 IAs for appropriate direction.
This is what, Kendrapada?
All
Yes.
are Kendrapada, my lord.
All are Kendrapada.
Then again, you have to tell us, Mr. Mohan.
The authority will grant the certificate, and unless the registration certificate is issued in favor of the farm,
No,
they
but
will
then
not
who's
be
there
eligible.
with the authority? Last time we got the
Mr.
secretary.
Padhi is there.
Mr. Padhi? Mr. Padhi?
Approval has been conveyed, my lord, but only
Audio.
certificate is waiting.
Mr. P.K. Padhi? I don't think he can hear us also.
Mr. Padhi.
He is muted from that side or this side also.
Both sides. Mr. Prasanna Padhi.
No, I think he's just muted.
Change phone.
We'll ask the secretary to remain present on next.
My lord, I am calling him within. I am calling.
From flag 199 to my lord 206. Flag 206.
Let's put down all these IAs. Flag 199-206.
Similar issues in case of Mr. Manoj Mohanty's case. That it is pending for issuance of certificate before the authority. What Mr. Sarangi's case and Mr. Mohanty's case same.
Similar. Firms and concerns who applied for permission to the district level committees for undertaking shrimp culture and are awaiting the Coastal Aquaculture Authority, right?
Yes, ma'am.
Chennai.
My lord, he is
All
there.
the directions had been issued by this court in para 14 of its order dated 4th April 2022 that their cases would be disposed of within a period of 4 weeks. These applicants state that they are yet to hear from the CAA, although there is an in principle approval granted by the DLC.
That is a recommendation. That is a recommendation.
Yeah,
Director,
we are not
12/1/2000.
We
Let me
cannot
place
give
the-
any.
Let me place the letter, my lord. With reference to the above, I am directed to convey the approval of the competent authority to recognize your farm located at such and such in the Kendrapada
In principle
shrimp
approval granted
culture.
by the DLC. Full stop. The secretary CAA is requested. Mr. Padhi, are you there?
Yes, yes, my lord.
So the same problem, sir. We are not that there's no solution now. See, 4th April, we had asked that Coastal Aquaculture Authority to dispose of all these applications within 4 weeks.
My lord directed, yes.
These people say they've not heard still. They're in September, 5 months are over, sir.
Well, I took up the matter, my lord.
We'll ask the secretary to remain present on the next dates.
Yes.
The secretary CAA shall remain present in virtual mode on the next date.
I may pardon, my lord. The secretary pollution board may be.
Yes, Mr.
This
Murugesan, yeah, you can. Thank you, Mr. Murugesan, for participating. We'll list it on 26th October. Something, no?
26th
October.
October.
26th October.
Fine, your lordship. All right. So, lordship, with your lordship's permission, your lordship have a glance to the last date orders. In this case, honorable court has directed to serve one copy to the government council. They have to file the counter in that case. In that case, what happened? 40 acres of pond, they are the recorded tenants pond. What they did, without any notice, they entered into my pond and they have demolished all those earthen garage without any kind of notice, nothing of any sorts. In that case, lordship, the one person, one lady, Anjali Sardar, 3 acres of land, the Tahsildar Tangi, without any intimation, nothing, any search, by taking the oligans, they have destroyed that pond, and the lady now is without food. That is under the Tahsildar Tangi and RI Circle, Bhushanpur, Lordship. In that case, 40 acres of pond has been demolished without any kind of
IA number.
That is 13 your Lordship's first order, last date's first order. Heard Mr. A.K. Vishal, that order only. In that case, I have served the copy to them. They are not respond in that case.
Mr. Mumbai, you're
Yes, my lord.
asking for copy of that.
13647. Yes.
You've not filed a
Last
reply.
chance.
Lordship, people are dying without food. Their livelihood has been taken away without any notice. 40 acres of land, around 10-15 farmers. They are the voiceless people. And they are telling that the boundary is from the coastal regulatory zone we have destroyed. Let them file an affidavit to that effect.
Yes, I will certainly file the reply on the next date. So far as 13647.
Food and
Okay,
you are
IA
paying the livelihood of
13647 of 2022.
Yes, my lord. 21, my lord.
21. You see, Mr. Mohanty seeks and is granted a last
Prashasam
opportunity
Patra
to file a reply within 3 weeks of the next day.
Neither option.
All right.
Lordship, another matter, that is item number 94. In that, it is to be heard this court. I have received the counter in this case right now. Interim order is going on. I will file the rejoinder. Lordship, interim order may continue.
Yes, I have served the counter copy today.
Item 94, interim orders to continue. Right.
Both the matters, Lordship.
Yes.
One Sanatana Balamantra is the petitioner and
93 and 94. All right.
Lordship, obliged.
Let's talk. Oh, they're all what, fishermen? Some of them must be this fisher folk. Export. Yeah, very rich, no?
Yes, yeah, please, Your Lordships. My lord, as your Lordships aware of it, this is a case of double murder. The person who has been murdered, one of the persons, Rabinder Swai, is a head of, was leading one group, and the other person is his field servant, my lord. So admittedly, my lord, there was a great village faction for which police personnel were also deployed in the village for quite some time. And regarding this conspiracy also, there was some information with the police that they are conspiring to do away with this leader of this party, my lord. My lord, before delving into the different circumstances that the learned court below has relied on to convict this instance, my lord, I will first start with answering 3 very preliminary questions that my learned senior has put. That is, his contention is that the FIR has been concocted because the first page of the FIR shows that it was against unknown persons. Well, my humble submission regarding this, that if your lordship will see the FIR as page, it indeed has two pages. The first page shows unknown, but in the body of the FIR, my lord, these persons' name have been clearly depicted. They have been clear allegations are there that on the basis of suspicion. When the IO was confronted with this, he has very bona fidely and honestly said that when the PW1 came to him with the FIR, he has not seen the assault. He has seen the post-occurrence. He is a post-occurrence witness, so he has his FIR is based on only suspicion. That is why it was referred that unknown, but then the FIR, he has entire thing has been exhaustively put down. My humble submission is that if one page of the FIR is concocted, why can't the second page would not also be concocted by him? In the case of unknown, they could have written down had it been a fabricated one, in the first page also, they could have written down the names of so this is a bona fideness that the IU has shown to show that it was only based on suspicion, so he has written the unknown thing. Secondly, my lord, my learned senior has harped on one thing is that medical evidence shows that there is some difference of timing, my lord. But as your lordships knows, the ocular evidence will always prevail over the medical evidence. And here there are two eyewitnesses not eyewitnesses to the assault, but one is a
proximate.
Yes, my lord, proximate. One is a and both PW3, he has seen these people going up and he has also seen them coming down with bloodstained clothes. And PW1. So basically the entire prosecution story has been based on the deposition of PW1 and PW3. PW1 is the brother of the deceased, my lord. My lord, I'll take your lordships to the circumstances, my lord, because that will be easier, my lord. To the circumstances that has been relied by the learned court below is at page 16 of the judgment, running page 34, my lord. First is, my lord, that there was a lordship.
Yes.
13, prosecution relies upon the following items of circumstantial evidence to bring home the charges against the accused persons. One, that there was a deep-seated village faction verging on enmity between the members of the prosecution party and the members of the accused party. My lord, this faction has been elaborately explained by PW1, PW2, PW3, PW7, PW13, PW14. All in different ways have explained that there exists a village faction of which this deceased was one faction and the other accused persons they belong to one. So there are enough evidence on record to show that there was a previous enmity existing between the parties. Second, my lord, that the members of the prosecution party were led by the deceased Rabi Swain and one Madhava Dalai, PW9. Though I will fairly submit, my lord, PW9 has not submitted anything in his deposition regarding the faction, my lord. He might be one of the targeted person because they also wanted to do away with his life. But yes, right. Honestly, my lord, PW9 has not said anything regarding the faction or that there was a conspiracy to kill him. That part is there. Third, my lord, that the accused persons in a meeting held in the house of one of them, Jadumani Swain, on 15 night, just 2 days prior to the incident, just 1 day prior to the incident, decided to eliminate both the deceased. This has been stated by PW13. PW13. No, disbelief. This have...
Today. We are exactly 31 years away. Exactly. That is our criminal justice system. We are still dealing with an event of 31 years old.
Yes. 5991.
Today.
Yes.
Fourth.
That has been disbelieved.
Yes. I'm just reading out the circumstances and I'll come make my speech. Item 4, clause 4 is that accused Sahadev Swain had heard this is Rabi Swain talking to... This has also been... Yes.
Has also been disbelieved.
This has also been disbelieved. I'm just reading it out. That accused Sahadev Swain, the main accused, had heard this is Rabi Swain talking to one Pramod Man Singh regarding higher income field servant in the grocery shop of Vidyadhar Swain at about 7 on the date of occurrence. But he has been disbelieved because the only effort of bringing PW7 into the PW6 into the scenario was to show that in front of PW6, the deceased, the accused had an idea that the deceased will be going to some place.
How can you please?
No, this was the idea of bringing PW6, but anyway, PW6 has been disbelieved by the Honorable Court. Then 5 is that this is Rabi Swain and this is Kubera Jani went to village Chakka Singh at about 9 a.m. on the date of occurrence, which is on the terrace of the Hilek. My lord, at this stage, my lord, PW1 is a person who says that his brother in the early morning has gone to Chakka Singh, another village, which they have to cross the hilltop and go to that village. He has gone, and when he found that he hasn't returned till evening or the afternoon, he goes along with one of his nephew. Of course, he has not been examined nephew. He goes along with one of his nephew just on the foothill of the hills. Foothill, there's a brinjal field of this PW3. There he meets PW3. PW3 there says that, yes, I have seen these accused persons, very specific. They were holding, two accused persons were holding katari. One was holding a sword, and three of them, there were 6 accused persons, and rest 3 were holding thenga. And all 3 of them had gone uphill towards Chhaka Singh. My lord, at this point, if I can bring your lordship to the spot map, my lord, it will be a little easier. Spot map must be there in the... Can I show it to lordship?
Yes.
Because the spot map is in Odia some portion, but nevertheless, my lord, I just wanted your lordship to appreciate the distance, the strategic place where PW3 was found, that is his field. And there is one path, one determined path to go up and come down.
Brinjal field. And where is PW3? The PW3 must be here somewhere. So these red spots are what?
My lord, red spots are the first deceased was beheaded.
Oh.
One spot, his body, his trunk was found.
Yeah, the head was found separately.
And your lordship, at this point, will appreciate that one of the witnesses has said that he heard this accused saying that we'll play football with his head.
My God.
PW7 says that he has heard this accused person saying that whatever be the consequences, let there be a compromise in the village also. We are not going to listen to the compromise. We are going to play football with the head of this main accused, Rabi Swine. So they have totally beheaded him. And the servant was found with 2 incised wound on his neck, cutting the pharynx, the trachea, and the neck.
Right.
But this has been very this assault. His first disease has been very ghastly and very. They were determined. It shows that they were determined to do away with that, with his life, and sever his head from his body.
Right.
Then circumstances number 6, my lord. The first 6 accused persons named above were seen going towards Chhaka Singh up above the Bhalleri Hill by PW3, Radkishan Baliyar Singh. PW3 is an independent witness, my lord. He says that he has no enmity with the accused persons. He has seen PW3, has seen them going up. Then, and sometime prior to 3 p.m. on the date of occurrence, armed with katti, sword, and lathi. Well, I'll elaborate a little later. I'll just finish the circumstances, my lord. Then circumstances number 7, that PWs 1 and 3, while ascending the slopes of Bhalleri Hill, heard a feeble, they have gone in search. They have heard a feeble voice entreating not to be killed, and the said voice was identified to be that of Rabi Swine, the brother. The brother identifies his brother's voice that don't kill me, but it's since dusk, the dusk was approaching, my lord. Was approaching, they could not find anybody. They went, and at this point of time, PW1 and 3, both of them see that the accused persons retreating with bloodstains on their clothes, and on seeing them, on being confronted by PW1 and 3, they have immediately taken a different, well, your lordship, see there's one path. They have not come down the path. They have dispersed into the jungle. Seeing this is the consistent evidence of both deposition of both 1 and 3. On seeing 1 and 3, they have immediately dispersed into the jungle. And they have tried to for the bride, they did not get, they have come back. The next circumstances is circumstances number 8, that PW1 and 3 found the above named 6 accused persons after a while descending down the slopes of Bhalleri Hill with katti, sword, and lathi, while the clothing were stained with blood-like substances. 9, my lord, that the above named 6 accused persons made a hasty retreat by way of receding into the jungle when they stumbled across PW1 and 3 and 2 others. 2 others have not been examined, so my lord, I will only confine my deposition to 1 and 3. Then 10, that PWs 1 and 3, going a little further, there are from the ever found a patch of blood on the Ghat road, just in front of a Bijes Thali of goddess Dalkhai, and also marks of violence on the ground. But they have not found the dead body, my lords. They have tried because it's a hilly jungle area. They have not found the dead body. They have only seen the blood patch and they have come back. Next is, my lord, that the above named 6 accused persons made an extrajudicial confession. Yes, this will have been disbelieved because, as your lordship, my lord and senior has also said, joint extrajudicial confession cannot be admissible. But here, my lord, the prosecution's version was they were in a rejoicing mood when they have come back, killing this, doing away with their enemy. They were rejoiced, and they, out of being euphoric, they have said that we have done away with the life. We have killed him. We have hacked him. That is so, my lord. In my humble submission, it cannot be a joint confession. This is an euphoric outburst after killing their sworn enemy, my lord. So it is not that they have come to PW8 and sat down and told him all 3 in verbatim and in unanimously that yes, we are the one who have hacked him. They were in a euphoric, rejoicing manner. They have expressed themselves, my lord. That is the extrajudicial confession that they have. That is how it has been taken, my lord. Okay. Then 8, my lord, that the above named 6 accused persons, while discussing something on the foot of Ballery Hill at evening hours preceding the date of occurrence, told one Bhikari Swai, PW7, that they would play football with the heads of Rabi Swai and Madhava Dalai, even if some settlement was reached or arrived at in connection with the village dispute. Your lordship will see this remote connection between this, the way they have said and the way they have committed the crime, my lords. So, and PW7 has not been, he has not been shaken with the cross-examination. 9, my lord, seizure of wearing apparels of accused. Number 2, Niranjan Rautre from his house, which were worn by him at the time of alleged occurrence, and the weapon of offense Katuri, concealed in the mango top of Uchav Samantre on 19/9/91, respectively at the instance of Pagala. Pagala is accused number 2, my lord.
That has also been disbelieved.
Alias Niranjan Raut and Seshdeva, having volunteered to give those articles while they were in post custody. No, discovery has been believed.
Completely disbelieved by the court. Next circumstance is also been disbelieved.
Because there is a leading to discovery Caesar witness also.
Yeah. Correct.
PW12 is leading to the Caesar to the leading to discovery, and PW14 also. Some clothes and bloodstained clothes. My lord, serological report is not in favor, of course, but there has been some recovery at the instant of the accused persons, and there are 2 witnesses. PW12.
That belongs to animal or human being, that is not there.
But nevertheless, there have been two Caesar witnesses. Then, my lord, the last but not the least, that some amount of blood was noticed in the nail clippings of accused Sadev Singh by chemical exam. That also, my lord, I will not harp much. My only, my lord, I will confine my submission to PW 1 and 3, where they have completely, exhaustively, very extensively, deliberately, they have deliberated on the faction, village faction, enmity, how they have seen, my lord. If your lordship will allow, should I go? There are big depositions, my lord.
Not necessary. You can just put it in your note.
So the 1 and 3, they have.
We will anyway be going through it completely. So.
Pardon, my lords?
We will anyway be going through it completely.
Yes, ma'am. And my lord, I will say that there are post occurrences witnesses also. PW 1, 3, 5, and 8. Not only 1, 3, 5, and 8 have also seen the accused persons coming down with blood stains on their clothes. 5 and 8, apart from 1 and 3. PW3 is a pre-occurrence witness, my lord. Conspiracy part, my lord, have been come forward with by PW7 and PW13. PW7 says
that has also been disbelieved. An elephant should not say something killing the violence.
PW7, my lord, let me take your lordship to
For
PW7.
that reason, I have not drawn the attention of the court about that. That has been disbelieved.
PW7, my lord, submitted before a lordship regarding the beheading of that we are going to play football with his head. And PW13 is a meeting held at one Jadumani's place where the accused persons were having a discussion and they were making plans to eliminate this person. And PW13 says that because he did not want to become a part of it, he has left the place and he has come away.
That is circumstance number 3 and disbelief.
Yes. So this, I'm just putting my submission, summing up, my lord. So the conspiracy part, there is some out of truth in the conspiracy part, my lord, because both PW7 and 13 have deposed. Then regarding extrajudicial confession, it is W8 who has spoken of the extrajudicial confession, and my submission to that, it may be accepted by the court because it was not an extrajudicial per se. It is an euphoric outburst of the accused persons after killing, leading to discovery, my lord, as I said, PW12 and PW14. And regarding the village faction, my lord, PW1, PW3, PW7, PW13, PW14, all have in clear tone and with a lot of clarity have said.
Also been disbelieved. Well, and friends, circumstance number 14 and 15, disbelieved.
14 and, my lord,
Say something.
14 is Caesar. I'm not talking of Caesar. I'm talking the village faction.
Seizure of wearing apparels of accused Niranjan and seizure of weapon of offense Katuri concealed in the mango top of Uchhav Savantrai on 1991, respectively at the instance of Pagala alias Niranjan Rautray and Sesadav Swai, having volunteered to give discovery of those articles. That has been disbelieved.
No, I'm on the village faction.
Village faction, they admitted.
Admitted. So no, I'm summing up before the lordships regarding all the points that I want to know and who said regarding this. And regarding the village faction, regarding the enmity, my lord, yes, my lord, I'm conscious. Enmity is a double-edged sword, my lord. But here, there's enough evidence to show that there was a very thriving enmity. Thriving enmity, why, my lord? Because police personnel was deployed there at that point of time. And there is also evidence on record, my lord, that these people have earlier approached the police saying that there's a conspiracy to do away with their life. Though those police personnel have not been examined, but there is on deposition. So there's a thriving enmity that in the village to which these people have taken advantage of, and they were determined to kill him, and they have found out the right time when these people have gone to that village, Hakka Singh village, and finding the right time and the right circumstances, my lord, they have done away with the life of this person. And why they have killed the servant? There is one suggestion, because the servant was obviously he was not a leader, but because he was there as an eyewitness, he has not been that brutally assaulted, my lord. He has been assaulted only with the neck. But this one has been very brutally assaulted, showing that there is some very deep-seated conspiracy, deep-seated enmity to do away with his life. Well, I'll close it here. And I'll give some decisions regarding the medical evidence superseding the ocular evidence, ocular evidence being more important than medical evidence. And second, regarding the fabrication and concussion of the FIR, my lord.
All right. Order is reserved. Correct. Order is reserved.